Good morning, everyone in the room. Welcome to the Planning Commission meeting of February 12th, 2025. We begin our meetings by a salute to the flag. Please join me.
To the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Very good. That continues on to our coverage of announcements, TV coverage, and roll call. Mr. Villalobos?
Thank you, Madam Chair, and good morning to the Commission. Planning Commission hearings are televised live on County of Santa Barbara Television, CSB-TV, Channel 20 at 9 a.m. in the South Coast, Lompoc, San Ynez Valley, Santa Maria, and Orca areas. Rebroadcast of Planning Commission hearings are on Fridays at 5 p.m. on CSB-TV Channel 20. Today's hearing will also be streamed live on the county's website as well as the county's YouTube channel and will be available for download in a day or two. Moving on to roll call. Commissioner Cooney.
Here.
Commissioner Park.
Here.
Commissioner Reed.
Here.
Commissioner Martinez.
Here.
And Chair Bradley.
Here.
Thank you.
Thank you. Secretary Wilson, do we have an agenda status report?
Good morning, Madam Chair and Commissioners. In regards to the status of our agenda, we have one item on consent and two items on our standard agenda. Just as a note, the first item, there will be a request for continuance, and I can share that date later during the projection report, but we can take up that matter once we get to the standard agenda. Other than that, staff and applicants and appellants are prepared to present on item number 2, which is the SB Can appeal of the Director's approval of Sentinel Peak Truck Rack project.
Very good. Please continue with the projection report.
So our next scheduled hearing will be on February 19th, and that will be in Santa Barbara. That is considered a special hearing. As of right now, there's one item on that. Well, there will only be one item on that hearing, which is a further hearing and consideration deliberation for the cannabis ordinance amendments. Again, that is February 19th, and that'll be in Santa Barbara. And then following that, we have our next hearing will be on February 26th in Santa Barbara. And there are two items on that. We have a housing project, and then we have the 2024 Comprehensive Plan Annual Progress Report. And then moving into March, we have one item on March. We had continued the appeal of the G&K Design Review Project to March 5th, and that's in Santa Barbara. And then on March 12th, we'll be returning to Santa Maria for two items. We had continued the discussion of the emergency shelter zoning ordinance amendments for that date, and also later today we'll get a request to continue the ambulatory surgery center project on Keysite 2 to March 12th. Again, that'll be here in Santa Maria. March 26th, we have no items projected at this point. And then in April 2nd, we have one item, which is a tentative track map. And then that's in Santa Barbara. As of right now, there's only one item on April 2nd. And then April 9th, we have two items, and that's here in Santa Maria, Tier 2 Winery, and then an equestrian facility. And then we have nothing further projected until we get down to May 21st, which is a coastal development permit on a wall in Santa Barbara. So that takes us all the way to May 21st. And I take that back. That isn't yours. That's Montecito. So our projection report ends on April 9th. So.
All right. Thank you. Any questions from the commission? Seeing none. Yes, Commissioner Park.
I'm just wondering if you have any way of estimating whether we're likely to have a hearing on May 14.
Jeff, can you hear
So,
me?
Madam Chair, there's a voice speaking from the cyber world, Mr. Seawards, who does like to look at the projection report a lot, and we can return to him to see if he has anything projected that's not on the projection report.
I don't have anything, commissioners, projected for that date. If you're interested in canceling it now, I mean, we could avoid scheduling anything for that date. And then one thing, Jeff, we put an item on last night for for March 26th. We just added an item on that last night. Those are my updates.
Oh,
You guys hear me?
yes.
Yes, thanks.
Okay.
I have a question about that.
Oh, yeah, Commissioner Cooney?
Thank you, Madam Chair. Mr. Seawards, the item on the 26th, do you have any identification for us?
Yeah, that is going to be a housing project, and that is a builder's remedy housing project in Isla Vista. And I just saw that staff put it on last night, so I didn't get a chance to warn Mr. Wilson this morning, so it's not his fault. But yeah, it's our first builder's remedy housing project, 27 units in Isla Vista.
All righty.
Thank you.
Okay, I think that brings us back to the question about which date you were wondering about was in, which date you? May,
The one I asked about was May
Right.
14.
May 14th. So hearing from staff that there's nothing projected, do we want to cancel that now, or is that too bold? Commissioner Cooney?
I'd move to cancel. It's always better to have advanced planning if we can do it, and staff is helping us with that date, so.
Commissioner Park?
Yeah, I think that would suit a purpose of mine that I'll discuss when we get to director's reports.
Okay.
Rather to commissioners' reports.
Okay, so Commissioner Cooney, do you want to make that motion? Can we do that now?
I did. I'll make it again.
Okay.
And I'll second it.
All right, there we go. Motion second, all in favor?
Aye.
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 All right. That brings us along to our, I'm sorry, wrong side, our public comment. I don't see any
Madam
slips, so.
Chair, I'm not in receipt of any slips, and for those of us joining online, if you'd like to speak at this portion of the hearing for items not on today's agenda, raise your hand and I'll call on you. Not seeing any hands.
Okay. That brings us to item 7, our planning commissioner's informational reports. Does anybody have something they want to share? Commissioner Park?
Yes, one, it just follows up on my question about that date of May 14 and 15. I received a communication, and I don't know how, because I rarely read my email, but maybe it came that way. And it was an invitation to go to an agritourism summit that's sort of a gathering of statewide people that are interested in that subject from the planning point of view. And it seems consistent with the kind of thing we've been looking at the last few years. It's May 14 and May 15, and I was hoping to go to that. But I just want to at least advise others that if that's something that interests you, take a look at it. And I'm not very good at reading these digital invitations or flyers, but it looked to me like it was it emanated from the University of California, Davis campus that has a sort of an ag tourism program. So I think that's who's putting it together.
Nice.
It's not just a commercial thing. Okay, that's one thing. The other thing I wanted to report on is that I attended with former Commissioner Freeney a dedication of Dan Blau Drive on Monday afternoon. And it was kind of more of a city of Santa Maria function than a county function, but it was just good to have some county people there, and it was very well attended. Windy day, which is appropriate for Santa Maria, I think. Anyway, but it was a lovely thing.
Yeah. Nice.
Yeah.
Aw. Okay, we are moving on then to the minutes, which is for January 29th, pardon me. Did anybody have any corrections to those? I want to make sure that the thing about the condition 31 was just the number that was errant on the page. It wasn't the condition itself. I'm sure you caught it, yeah. So, is there a motion to approve those?
So moved to approve them?
Okay. I think Cooney beat you to it, and then Park seconded. Okay. Okay, all in favor? No corrections?
Aye.
Great. Aye. Great. That brings us to our director's report. How are we doing that? Okay. From the Ethernet, yes.
Hi. Hold on one second. Okay, I have a few things to report on from board action. So yesterday, the board heard the lighting and signs program, and they did approve it. It was actually a 3-2 vote. I think there was some sentiment from the supervisors from the north that some of the requirements that were being implemented could create more sort of neighbor on neighbor reporting of violations of different lighting that didn't comply with the new code. And I think they decided they wanted to vote against it. But there were a couple of changes that were made in the lighting and signs. One is WeWatch had asked that we put something in the purpose and intent of the code about lighting to make sure that it was clear that part of the reason for these regulations was to protect wildlife and biological resources. Board did support the no uplighting of landscaping. And then they decided they wanted to go with 2,700 kelvins on the lighting rather than 3,000, which was what we had up to 3,000, I think, in the code. Any questions on that? Okay. Then on the 4th of February, it was an all planning and development day on the departmental agenda. We had the Blanco appeal scheduled or Cargasachi, and that was actually withdrawn. They managed to work it out. So that's positive. We did have the Coastal Resource Mitigation Fund program go to the board on that day. And there were a number of great programs that received funding, including the aquarium at Cabrillo High in Lompoc, which is always a crowd pleaser. I mean, they do such a great job. We were helping fund a new exhibit, and they did get some donations from the Monterey Bay Aquarium. And we're going to help them develop those exhibits out. We had Nature Track was one of the recipients. They're the organization that helps handicap folks get out on the beach and see natural resources, as well as a number of other. I think we funded a bike rec program for the city of Santa Barbara, helped fund that because of all the new. We're seeing a lot of electric bikes out, and so there's just bikes all along the coast and not sufficient racks. So we're helping do that. We didn't have any acquisition requests this year, so that money is going to be rolled over to the next cycle. We had the SB 9 and telecom ordinance amendment package, and the board approved both of the packages. There was one matter that there was a disagreement between Montecito Planning Commission and the County Planning Commission on the recommendations, and that had to do with requiring that the new unit in an SB 9 project be affordable to low or moderate income households, and the board decided to maintain that provision into the code. They did allow for existing applications to continue through the process without being impacted by the ordinance. And the way they did that is they made the ordinance effective, I believe, 120 days from the board's action. And they had the second reading yesterday. They also approved the Coastal Commission's modifications to our housing bill package. And that was the provision that the county take up converting subjective standards in the local coastal program to objective standards in the next 3 years. And that's something we'll be including in our work program. A couple other things just to keep on your radar. We are getting prepared for our budget hearings. Those are going to be in April. They will be, give you the dates. They will be the 15th, 14th, 15th, and I believe 18th. I think that's correct. It's that week. There are 3 hearings scheduled that week. Could be the 15th, 16th, and the 18th. No, I think it's the 14th and 15th. So if you're interested in monitoring that, that's when those will be. And we will be taking the work program to the Board of Supervisors either on the 1st of April or the 8th of April. We'd like to take that in advance of the budget hearings. Upcoming board items include the Sable appeal, which will be on 2/25. And then I think I've advised you that this Community Services Department is taking a workforce housing on March 4th, as well as updates to the inclusionary housing ordinance on March 4th. And that's all I have to report today. I'm happy to answer any questions.
Okay, seeing none. Thank you, Director Plowman.
Great, thank you.
Okay, then let's, she fades away. That brings us to our consent agenda and procedures, and we have one item on our consent calendar. Do you want to read that into the record?
Yes, thank you. The following is a hearing on the request of Andrew Kish, Community Services Department, Housing and Community Development Division. Consider case number 25 GOV1 for a determination that acquisition and disposal of certain real property conforms with the comprehensive plan of the County of Santa Barbara pursuant to California Government Code Section 65402A. And Mr. Kish is online as well.
Okay, so as a consent item, we generally don't even get a staff report. Is there anyone on the commission who wants to pull it off the consent calendar? Seeing none, then I'm sorry.
I'm sorry, Madam Chair. Yes, I had a call from a couple of members of the public about these hearings, wanting to have an opportunity to consider them, or at least have the Planning Commission consider them. And so I would like to be able to say that we understood just exactly what the proposal is.
Okay, so I think that's a motion to pull it off the consent calendar and have it considered now, right?
I don't think we need a motion for that.
No. But maybe we can get staff to give a quick report.
Sure, Mr. Kish is online.
So, Madam Chair and Commissioners, we have representative from that department requesting the 6542, and Ms. Baylor's here as well. And the planner is. So, Madam Chair, if we could just have Ms. Baylor present any information, then we can ask questions of the representative.
Sounds good.
Thank you, Madam Chair and members of the Commission. We don't have a PowerPoint or anything, but I'm happy to provide some of the details that were given in the staff report that Steve Connor prepared. Steve is also available if you have any specific questions. So this is a request of Andrew Kish. He's in the Community Services Department, Housing and Community Development Division, to consider an application to acquire a unit, a deed-restricted single-story affordable housing unit in a condo building at the Villas at Summerland. So the purpose of this unit is to serve rehabilitating and, disposing of the deed-restricted affordable housing unit at a below-market rate. Once the unit is required by the county, HCD will issue a request for proposals and identify at least 3 potential buyers, which would be very low income, to participate in a lottery to determine the order in which to process home ownership applications for this unit's purchase. So this land and the unit will be subject to a recorded deed to preserve the affordability of the unit with a longer term covenant, so this would be between 45 and 90 years upon the date of the sale. So I hope that helps give a little bit more information. That's just directly from the staff report. If you have any additional questions on the purpose of the acquisition, I think we can direct that to Andrew.
Okay, I do have one question. Is he on? Oh, okay.
I am.
Great.
Good morning. Yeah.
Good morning, Mr. Kish. How are these units vacant and available for acquisition in this case?
The current owner provided the county with a notice of intent to sell, and the existing deed restriction grants the county the first right of refusal and the option to purchase the unit in that event.
And I don't have the documents in front of me, so could you just give me an idea of where this is in Summerlin?
Adjacent to Ocean View Park, just off the 101 freeway, just, I guess, kind of east of the town of Summerlin. I could bring up a map specifically. I have an APN number as well if you need, but the Vias at Summerlin is the development, and I guess it's in the eastern portion of Summerlin, in the unincorporated area.
Madam Chair, I believe we've allowed Mr. Kish to share his screen if he wants to bring up a map.
Okay,
One
that'd
moment.
be good.
While we're waiting for that to come up, Madam Chair and members of the commission, I just wanted to add that P&D's role in processing these requests is to determine that it's compliant with the county codes as applicable. So that's what we've done here.
And, well, this is sort of an interesting thing because the county required affordable units for many decades under its inclusionary housing program, which I understand is going to be changed. And as they come to the end of that term, then the county has a chance to buy it back and then sell it in keeping in the affordable program, right? So it'll be interesting to see how many more of these come up because in the 80s and 90s, we had sort of a building boom with residential units. And so a lot of them might be coming up to their time. I'm not sure if all of them were 50 years, 45 years, you see them with different things, but this will be the first process that they go through and the county as first right of refusal has a chance to keep it, and that it's administered under the county general services department, or do we do it with the county housing authority?
The administration. All right, go ahead.
Mr. Kish, go ahead. I think you have that answer.
The county community services department has a housing and community development division, and we're tasked with the enforcement of Chapter 46. These units within the affordable units within this development were built for the purpose of providing below market rate units to the workforce. So county HCD does administer this inclusionary housing program under which these units were created.
So Madam Chair and Commissioners, just as a refresher, so the action before the commission isn't so much in regards to the buying and selling of this. It's really whether it's consistent with the comprehensive plan. And so we're not really taking action on whether or not it's appropriate or not to purchase or sell this. It's whether or not that action is consistent with the comprehensive plan.
I got it. Did you have any other questions, Commissioner Cooney?
I do not.
Okay.
I'm ready to.
I had one
Oh,
too,
okay.
and I wasn't going to bring it up. I should have called staff ahead of time. But on page 3, I know it's a general plan consistency thing, but we're talking about the third line down, and you're conforming the design residential land use designation. Did we get rid of that designation? in a recent package? I thought can anyone help me with that? I thought
So, Madam Chair, Commissioner, I think Ms. Reese has answered that, but I don't recall that
I
action.
thought we got
occurring.
rid of some kind of design residential.
Madam Chair, members of the commission, the design residential zoning designation zoning designation still exists and is the zoning designation that you applied to the housing element rezone sites as well.
Okay, I'm probably thinking of some other category that we slimmed down in some ordinance amendment, but if this is it, that's fine.
Shopping center, maybe. That one did get nixed.
Yeah, I thought it was some kind of, okay, thank you. So with that, Commissioner Reed.
I just have a question. It's based on the description. It says the parcel is zoned DR 2.5 and contains a deed-restricted single-story affordable housing unit in the condominium building. So it's actually a condo, not a piece of ground. Is that correct?
That is
Or
correct.
is
It is
a piece of ground?
That's
Excuse me?
correct.
Okay, so then even though it gives the size of 0.02 acres, that's, according to my computations, it's about 870 square feet. Is that correct?
I want to say closer to
correct.
9. But yes.
Okay, just my confusion. It's called a parcel, and it gives a size in acres, but it's really a condominium. Okay, thank you.
Okay, Commissioner Cooney, did you have anything else?
No, I was just prepared to
Take it away.
make the findings that are needed under the code section. What's the number of the code?
The recommendation is just to find it consistent.
Yeah. So our motion is to determine that the proposed acquisition and disposal of this parcel conforms with the comprehensive plan, including the land use element, the housing element, the coastal land use element, and Summerlin Community Plan, and that staff transmit the conformity report required by Government Code Section 65402A to Andrew Kish, Community Services Department, Housing and Community Development Division, and to the Board of Supervisors. That's the motion.
Okay, do we have a second?
Second?
Commissioner Park seconds. Do we want to do a roll call or?
Happy to. Commissioner Cooney,
Aye.
Commissioner Park,
Aye.
Commissioner Reed,
Aye.
Commissioner Martinez.
Aye.
Chair Bradley.
Aye.
Motion passes 5-0.
Thank you. So that brings us to our standard agenda, and do we need to take a motion to continue on item number 1?
So I think I should read it into the record, and then we need to take public
All
comment.
right, I'm just,
But I appreciate your enthusiasm.
go ahead.
The following is a hearing on the request of the owner, Taylor Judkins, to consider case number 24 AMD, case number 24 CUP 19, and case 24 LLA 2, and to determine that the previously accepted addendum to the Certified Orchid Community Plan OCP Environmental Impact Report 95 EAR 1 is adequate environmental review for case numbers 24 CUP 19, 24 AMD 9, and 24 LLA 2 pursuant to section 15162 of the state guidelines for implementation of the California Environmental Quality Act.
Thank you. That brings us, actually, we have to do ex parte and everything, even though we're continuing it? Okay. Does any commissioner have an ex parte disclosure that they want to make on this item? Okay. Seeing none, then we would go for a motion to consider, or does staff want to make a comment about it?
Madam Chair, I think staff can make a comment. I think it's in a memo to request the continuance. Before we do a motion, we do need to open up for public comment.
That's right.
And that public comment would be on the request for the continuance, because I think that's the direction the commission's going, is to have a motion in action on the continuance request. And if Ms. Reese wants to add anything to that, she can. Otherwise, we can do public comment. And I think the date was March 12th.
So March 12th is the projected date, and let's go to public comment. Is there anyone online or that wants to speak to this?
Madam Chair, there are no hands raised.
Okay. And we'll close the public comment and bring it back to the commission for, if anybody wants to hear anything more from staff, but I think it's covered in the memo. Does anybody want to hear anything from staff, or we can just go to a continuance motion? Does anybody want to make that?
I'll move to continue this matter.
Okay. And we have, the date was March 12th. You
To
wanna-
March 12th.
Thank you. Commissioner Reed?
I'll second.
Very good. Do we roll call that?
Commissioner Cooney,
Aye.
Commissioner Park,
Yes?
Commissioner Reed,
Yes.
Commissioner Martinez. Yes. Chair Brightly.
Aye.
Motion passes 5-0.
Thank you. Okay, that brings us to our second item on the agenda, our main event. Mr. Villalobos, can you read that into the record for us?
Thank you. The following is a hearing on the request of the Santa Barbara County Action Network to consider case number 24 APL for the appeal of the director's April 27, 2024 approval of the Sentinel Peak Truck Rack Project case number 22 LUP 199.
Thank you. As an appeal, we, at this point, disclaim ex parte communications and site visit disclosures. So who on the commission wants to start us off on that? Commissioner Reed?
Yes, last month I had a visit with the Sentinel Peak people, also attended by Commissioner Park at their Price Canyon facility to observe just what a truck rack looked like physically and to discuss their Lompoc trucking project.
Okay. Commissioner Park?
Yes, I attended that meeting with Commissioner Reed. I also had a follow-up telephone conversation with David Buddy. And and I met with Ken Huff, and I had a follow-up phone conversation with Ken Huff, and also a phone conversation with Mark Chatillo. I went on a site visit approximately a week and a half ago, and then another one on Monday. And I have some materials relating to those site visits that probably Ms. Richardson will advise me on in a moment. And then I'm leaving something out. Oh, yes, and I spoke briefly about this, the oil field with former Commissioner Farini, and then had a follow-up phone conversation with him. He doesn't take sides on this. It's not that. He just was involved 10, 15 years ago when PXP had the oil field, and he was hired to do a survey. So he did a survey of all the sites and took pictures and their condition. So he's just extremely familiar with that oil field from the basis of that survey. Isn't that an odd thing?
I was going to say, I thought he was a farmer. Yeah, what was he doing during that survey? Interesting.
I can't remember. It was a big deal then because it had to do with a potential transfer by PXP, which is the pipeline people, of the whole field to the state in return for being able to drill oil on the Tranquillon Ridge, which is out in the ocean. It was just a big deal, and it was rejected by state Tidelands or some state commission. But he was involved in that somehow doing this survey. And you'll have to ask him about it. He still has his equipment and things and so forth.
Okay. Does anybody else have an ex parte? I do. I spoke with Meryl Brooks last week about the appeal that's outlined in our material today, as well as Ken Huff with SP Can yesterday. And I've spoken several times with the representatives of Sentinel Peak, including a call yesterday about the letter from the appellant, and I think that's it in terms of ex parte disclosures. All right, Commissioner Reed.
I did have one phone call with Patty Cook following our meeting that I'd forgotten to mention.
I should have used Patty Cook's name. That was who I talked to several times. So, okay, with those disclosures being done, we go to staff's presentation.
You know, if I could.
Actually, County Council
County Council, and just to introduce that.
Right.
We've had sort of a running discussion, which has been very fruitful for me, very useful, with Ms. Richardson and Ms. Kim on submission of a reliance on evidence that's adduced outside the hearing, and then getting documents into a hearing by planning commissioners, and what's the right time to do that, and so forth. And I've spoken to other folks that have been involved in this in the past and gotten very good advice that's often conflicting, including from Supervisor Hartman, who was a planning commissioner, as you all know. So maybe Ms. Richardson could state what we kind of came up with. And,
Chair Bradley and Commissioners, so Commissioner Park has a few images that have been provided to the clerk and are ready to be displayed. And for ex parte purposes, the reason we discuss ex parte disclosures is so that the commission all has the same information to make a decision. So Commissioner Park has some additional pictures he'd like to share or discuss, and he's going to raise those during questions on staff's presentation, so there's a little bit more context to them.
But we're looking at them now, so the applicant and appellant also see them?
When they're looked at during staff's presentation, that'll be before appellant and applicant present, so everyone will have the information before they speak on the project.
Got it. Okay, then I think we are ready for staff's presentation.
Madam Chair, good morning. Aaron Briggs here. I have Ms. Jacqueline Ibarra, who is a staff person on this project, who's going to give the presentation this morning remotely.
Ms. Ibarra.
Good morning. Hi, good morning from the cloud again. Good morning, Madam Chair, commissioners, and everyone in the audience. So today the commission is reconsidering the Santa Barbara County Action Networks, or SBCAN's, appeal of the Sentinel Peak Truck Rack project. The appeal was last before the commission in detail in August of 2024. It got postponed a couple times, so I'm glad we're back before you now. As Mr. Briggs mentioned, I'm the case planner, and he is in the hearing room. So let's get into it. Next slide, please. So to recap, the request is to consider SBCAN's appeal of the director's approval of Sentinel Peak's land use permit, which authorizes, one, the construction and operation of a single truck loading rack and associated infrastructure within the Lompoc oil field. It authorizes the trucking of produced oil from the field over to Coalinga, California, with an average of 6 and up to 10 trucks per day, with a trucking timeline of up to 50 years or until an export pipeline becomes available, whichever is shorter. The project is a request of Sentinel Peak to be able to restart their production and export their oil due to the unavailability of the Phillips 66 Line 300, which exported Sentinel's and other various operators' oil until it ceased operation in early of 2023. Lompoc oil field has operated for over 120 years in the county under vested rights and used the Phillips 66 pipeline to export oil as it was the county's preferred export method. The field is currently shut in. It has been since the pipeline went down and cannot produce without an export method. And if the project does not approve, operations could potentially be permanently shut down. Next slide, please. So this slide shows the project location. It's within the Lompoc oil field, outlined here in green, which is located north of the city of Lompoc. The project site is a very small area of the oil field, which is outlined in yellow here. Next slide. This slide shows a close-up of the project area. It's located north of the independently owned and operated Lompoc Oil and Gas Plant, which is located off Harris Grade Road and outlined here in red. And the right slide shows a close-up of the proposed construction area. Next slide. The project would consist of a single truck loading rack, accessory gathering lines, secondary containment for any on-site spills, designated stormwater drainage, and power poles. Construction would be within all previously disturbed areas and would take about 3 to 6 months with 10 employees. The schematic on the right shows a visual. Oh, sorry. Thank you. Shows a visual of what the truck rack would look like. And the construction itself would be very minimal. Now, next slide. The project would also include the transport of crude oil via standard 160 barrel trucks with an average of 6 truck trips per day. However, in reality, based on Sentinel's historical export averages, they will likely transport less than 5 trucks a day. The permit would also authorize a maximum of 10 trips per day under certain circumstances, and that would be in the case of temporary shut-ins for maintenance or weather delays. The trucking route is shown in the figure on the right. It would start at the Lompoc oil field, travel down Harris Grade Road to Highway 1, over Highway 135, connect to Highway 101, and then over the valley via Highways 46 and 41, up Highway 33 to Coalinga. Next slide. We also wanted to highlight for background and context that SBR's project is not unusual. In fact, they are the only onshore operator in the county who doesn't have a truck rack. It's common industry practice to truck to pump stations and refineries throughout the state. There are approximately 15 other oil and gas operations within the county that rely on existing truck racks to deliver oil to market. They are an essential feature of oil field infrastructure and are a predominant method of transporting oil from smaller oil fields. Also outside of Santa Barbara County, SBR successfully operates a truck rack to transport oil from their Arrondo Grande oil field or Price Canyon in San Luis Obispo County over to Kern County. And again, without a truck rack or the restart of the pipeline, SBR could potentially lose their operations within our county. Next slide. This project was processed as a land use permit, and we also conducted environmental review under CEQA. So Planning and Development prepared a mitigated negative declaration, which was circulated to the public last year, including notifications to tribes under AB 52 and all state agencies, including Caltrans. We received minimal comments back on the MND and incorporated all of the relevant ones into the final document, including some from SBCAN, other local parties, and some clarifying comments from our APCD. The MND determined that there would be no significant and unavoidable impacts from the project. There would be less than significant impact with mitigation incorporated for 2 issue areas. Those would be for biological resources and risk of upset. I wanted to highlight that for risk of upset, a comprehensive third-party risk analysis was conducted and determined that the project trucking would be less of a human health risk and less of a risk to the environment than transportation by Line 300. And also the statistical risk of an oil spill from the project trucks would be once in 239 years with the mitigation measures incorporated. The MND also determined that the project would result in less than significant impacts for all other issue areas, including transportation, and all those issue areas would not require any mitigation measures be incorporated. Next slide. This slide shows the measures that were identified in the MND, shown in the left-hand column, and they are now carried over as conditions of approval. They address various measures to protect biological resources within the truck rack development area, as well as a host of safety measures for the trucking of oil, to both reduce the likelihood of an accident and oil spill and to lessen the severity if one were to ever occur. Those measures include implementing a truck hazard mitigation plan, updating spill response and safety documents, having the trucking company demonstrate certain sufficient financial responsibility, implementing an oil spill contingency plan, placing a restriction on trucking during rainy days, and requiring reporting on all trucking activities. The right-hand column shows some of the county's standard measures that have also been applied to the project, such as APCD's air quality measures, implementing an erosion control plan during construction, and monitoring for ongoing compliance. Next slide. This slide shows a summary of SBCAN's appeal issues, which were all discussed in detail in the August 2024 hearing. I just wanted to highlight the conclusions from those issues. One, that the project does meet the criteria for a land use permit per the county code. Two, there's no public hearing required for land use permits and all noticing was completed. The reason, obviously, why we're doing a public hearing today is because the project was appealed. The project's MND determined that the most severe impacts would still be less than significant under CEQA with the mitigation measures incorporated. That all comments on the MND were considered and revisions were made where appropriate. And finally, that no disadvantaged communities are present along the truck route and that CEQA does not require those impacts to be evaluated. Next slide. So at the August hearing, some commissioners did have concerns regarding the project. The concerns included that not all local agencies along the truck route were notified of the project. Two, that future housing developments could create hazards along the truck route due to population growth and additional traffic. That there should be a way for the project to be able to respond to community growth and transportation related hazards over time. And there was also a question if the project was consistent with the county's 2030 climate action plan. Next slide. Because of those concerns, the commission continued the item and directed staff to implement the following. So one, to provide notification to all affected agencies along the truck route. In response, we provided secondary notices to San Luis Obispo County, the city of Lompoc, and the city of Santa Maria. And we also sent notice of the project and the MND to Monterey, Kings, and Fresno counties, as well as the city of Coalinga. No comments from any agency have been received to date. Next slide. Second, the commission directed staff to show future housing developments and transportation improvements in the Y area of the truck route. That's the intersection of Harris Grade Road and Highway 1. In response, staff added information regarding the Burton Ranch project, which will develop approximately 476 lots beginning this year. Transportation improvements under that project are listed here and include new collector roads, designated turn lanes, bikeways, pedestrian crossings, certain fire protection buffers and setbacks from property boundaries, sound walls and landscape buffers, and also certain setbacks from the roadway. Next slide. This slide shows the major improvements from that Burton Ranch project. When the project is constructed, it will add use to the area. However, there are various transportation safety improvements that will also be added to those areas' local roadways. Next slide. In addition to the Burton Ranch, there are also other development sites within the county in various application stages. If they are approved and developed, transportation improvements may be similar to those of Burton Ranch. In the table here, you can see 3 sites that are near SBR's truck route, including 1 in Vandenberg Village and 2 in Orchid. And these are from Santa Barbara County's housing element. Based on the element, the Lompoc Valley could see a 9% increase in vehicle trips in the area by 2031, and the Santa Maria Valley could see a 60% increase in vehicle trips. Next slide. Third, the commission wanted the applicant to consider including a voluntary adaptive management plan as a way to respond to future development and identify hazards along the roadway in real time. So SBR agreed to this request and revised their project description to include the following adaptive management plan. It's not statistically likely that project trucks would be involved in an accident. However, if they are, you can see from this table that actions would be required if there was an accident with any 12-month period of trucking. And responses would be required if project trucks are determined to be at fault. The AMP table first lists the accident types on the left-hand column, which include non-injury accidents, injury accidents, fatalities, and oil spills. The middle column shows the thresholds and requirements for a level 1 response, which I'll go over in detail in the next slide. And the right-hand column shows the thresholds and requirements for a level 2 response. Next slide. Under level 1, if project trucks are involved in a non-fatal accident, SBR would immediately notify law enforcement and emergency services. They would notify the county within 24 hours and provide all publicly available accident reports. They would then detail the incident on their quarterly trucking reports that would already be required under their COAs. And under level 2, if project trucks are involved in 2 or more non-fatal accidents or 1 fatal accident or an oil spill, they would complete all the required noticing above. They would also complete a comprehensive investigation to determine fault and liability. If project trucks are determined to be at fault for the accident, SBR and Planning and Development would then consider the following adaptive management responses. These could include stopping work during extreme weather events. This would be for things like damaging high winds, extremely dense fog, wildfires. The threshold for these extreme weather events are based on National Weather Service definitions, and those are detailed in the staff memo. Responses could also include a change of trucking company to another company with at least the same or a better safety rating. And responses could also include restricting trucking during certain hours, such as during local school drop-off and pickup times for communities within the county that are along the trucking route. Next slide. If any measures are implemented, Planning and Development would submit a report to the commission that would describe the incidents and the measures implemented. Also, every 5 years, SPR would review the adaptive management plan and update it with any new safety measures or responses that may become available over time. Those new measures would only be implemented when those level 2 thresholds are reached. And if trucking is still occurring 25 years after the permit is issued, Planning and Development would also submit a report to the commission. That would be a comprehensive administrative report that would describe the project status, any incident reports, accident trends, and AMP measures implemented. This AMP has been incorporated into the revised project description, as well as the conditions of approval that are included in this version of the staff memo. Next slide. There was also a concern last hearing if the project was compatible with the county's 2030 climate action plan. So we took another look. It is written up in the MND, and that plan really focuses on reducing emissions where the county has direct influence over an industry sector, such as supporting sustainable businesses, funding carbon sequestration projects, etc. The CAP recognizes that the oil industry is an independent industry with significant economic and cultural presence within the region. It has a goal to explore strategies with the industry to potentially phase out fossil fuel extractions, but recognizes, aside from permitting authority, it doesn't have direct influence over the oil and gas industry, and it doesn't have any moratoriums or directives for existing oil and gas operations. The project is also consistent with the county's comprehensive plan, the land use and development code, and that analysis is described in the August staff report, which is included as an attachment in your current staff memo. And finally, we determined that all findings can be made, including CEQA findings and administrative findings for land use permits. Next slide. Therefore, staff recommends that your commission, 1, deny the appeal, 2, make the required findings for approval, 3, adopt the mitigated negative declaration and the mitigation monitoring program, and 4, approve the project subject to the conditions of approval. Last slide is just our conclusion page. That concludes our presentation, and we're happy to take any questions. Thanks.
Commissioner Reed?
You noted in the presentation that about 15 oil operators in the county use existing truck racks and therefore truck their oil. Is that correct?
Commissioner Reed, through the chair. Yes, that's correct.
Okay, so...
And Commissioner Reed, if I could also add to that, we do have several operators that are produce more oil than Sentinel Peak and therefore have multiple truck racks. I think PCEC has at least 3, and Cat Canyon Resources has at least 3 or 4. So there also are several operators that have more than one truck rack.
Okay, then, because we'd had a comment in a prior meeting that there was a thought that Santa Barbara County was a no oil by truck county, but Santa Barbara County has no policy or ordinance that would prohibit trucking oil. Is that correct?
That's correct.
Okay, thank you.
Commissioner Park?
Yeah, I'm going to follow up on that last item. And isn't it true, Mr. Briggs, we also have oil that's trucked into the county, for example, light crude that comes into Cat Canyon for dilution purposes?
That's correct. So the oil that is produced locally sometimes is rather heavy, especially when it's produced thermally. And operators who use cyclic steaming or produce a heavier crude will oftentimes import a lighter crude to blend with it to make it easier to transport.
Let me ask about, follow up on the question on policy. And this is one where I'm going to bring up that excerpt from the Exxon order. Can you pull that up, Mr. Villalobos? This is sort of the 800-pound gorilla in the room, this idea of do we have a policy or not. And I think it's important that staff has the opportunity right now at the beginning of the hearing to make it real clear what their position is. And by staff, I mean both Mr. Briggs, but the Energy Division, but also County Council. Okay. What are the cute puppies? Oh, that's a kitten. Okay.
And where is this from?
This is drawn from the order by Federal District Court Judge McKee on the summary judgment motions from various sides that were all heard together in the lawsuit that ExxonMobil filed against Santa Barbara County after their trucking project was rejected. And I've drawn from it for a number of reasons. We'll get into the earlier parts of that paragraph later. But if you look at line 11, it says, there is no de facto ban on trucking oil in Santa Barbara County, nor does this decision cause one. And that's a question I have in it. As Mr. Briggs pointed out, that there is no written policy in ordinance or general plan against trucking oil. And so here Exxon said, well, Santa Barbara County has a de facto ban, okay? And the judge said, no, there is no de facto ban, no de facto policy, no unwritten policy on trucking oil in Santa Barbara County. Could you elaborate on that, Ms. Richardson? I mean, is there a policy that exists even though it's not written?
Madam Chair and Commissioners, there's not a policy that I'm aware of. Part of the reason we're here today is because trucking is allowed with a particular approval of a land use entitlement. So it's within your commission's discretion if the findings to be able to truck can be made for this particular project.
And if the Planning Commission today held that we do have a de facto unwritten policy against trucking oil, that kind of might undermine our position that was taken in the Exxon litigation. Is that right?
Madam Chair and Commissioners, I don't think the question before your commission today is whether or not there's a de facto ban. The question is this particular permit and whether to approve or deny or require more environmental review.
And like all of our decisions, we first look to see, okay, is there a prohibition against the action we're asked to take in the law? And then we need to look at our findings. Do they support our action? And then does the evidence support our findings? So we need to do that today and look at what's actually happening here, correct?
Madam Chair and Commissioner Park, so staff does sort of initial review of what permits required, and they've put together a consistency analysis of the applicable policies, and there's no ban of trucking in what they've prepared.
Yeah, and I'm sure you're aware of a letter that was submitted by Get Oil Out that quoted from the board letter from the Board of Supervisors following their decision on Exxon trucking. And it said, and I'm paraphrasing, that Santa Barbara County doesn't allow oil trucking. And arguably that is in fact a policy that's announced by the board because they signed the board letter. Do you have any response to that? It's going to come up, so people might as well know what the response is of staff.
Madam Chair, Commissioner Park, I was just checking because there's been so many projects. I couldn't remember if the board reached a majority vote on Exxon trucking or if this was one of the tie vote ones.
It was a majority one because it wasn't a pipeline case.
I'd have to look at the particular findings in the board letter, but what's before the commission today is a different project.
Okay. Well, anyway, you'll see the Get Oil Out letter that was submitted to us, I think the last time that we continued this, was that December? I can't remember. Anyway, it's there in the record, and I'm sure it will be brought up by in public comment. So let me go on. I need help with something. I wanted to refer to something that I thought I read in the staff report. I mean, the latest staff memorandum, but I've also read the staff memorandum, the original staff report, the MND, the QRA, and I'm kind of confusing where I saw things. And my recollection is that we have a prohibition in our code that means you cannot take trucks this size south of the crossing of Burton Mesa Road and Harris Grade, on Harris Grade Road, down to the intersection with Highway 1 without a waiver. And that you can get the waiver if you show there's no other direct access. Does anyone can tell me where that is in this report?
Mr. Chair, or Madam Chair and Commissioners, we're just looking at each other. Oh, maybe Jax can answer that, if that's a Caltrans requirement or county, I'm not sure.
Yeah,
Just to
Commissioner
clarify,
Park through the chair. So that is described in the M&D under the transportation-related impact section. There is a requirement of county code that a certain weight of vehicles can't be on that portion of Harris Grade Road. However, it specifically exempts vehicles that have no other direct access and that are supplying or delivering goods to and from the site. And so in that case, this project would be exempt from that portion of the code. It doesn't require a waiver. It just falls under the exemption.
So there's an exemption, but the exemption relies on a finding that there is no other direct access, correct?
Commissioner Park through the chair, that's correct.
Who makes that finding?
It's not a finding. Madam Chair and Commissioner Park, I don't believe that that's a strict finding, a formal finding that needs to be made.
Right.
It's just part of the language of the policy.
Right, and who ultimately decides it? I mean, do we leave that up to a Superior Court judge if there's a prosecution that there is direct access, or is it before us? You know, if we see an alternative, is that important?
So I think in the consideration of the project and the director's approval, it was staff in combination with the director who interpreted that policy, and now it would seem that it would be before the commission.
That makes sense to me, because one of our findings, of course, is that this is in full compliance with the law, and that would be a relevant portion of the law, so that would be something we need to incorporate in our findings, whether it's implied or explicit. Okay, thanks. I just couldn't remember where I saw that. We'll get to it later. Next question I want to ask is, were there any traffic studies done about this area in relation to this project? I couldn't find them.
Jax?
Commissioner Park through the chair. So there were no formal traffic studies done because transportation impacts with only 6 trucks isn't a significant impact. CEQA doesn't require a level of service or congestion be analyzed anymore. It only focuses on vehicle miles traveled, which industrial trucks are not included in that analysis. So the transportation impact analysis in the M&D really focuses on county policies, if it's conflicts with any county policy, if it introduces a significant hazard due to roadway designs, and if it meets VMT criteria.
Correct me if I'm wrong, but it looks to me like the mitigated negative declaration, the MND, and the QRA, which is a quantified, what is it again?
It's a quantitative risk analysis.
Quantitative risk analysis. I would have gotten there in 5 or 6 minutes. They don't take on-the-ground data from this area. They rely on California Highway Patrol statistics on average accidents on 2-lane highways and on freeways. Isn't that correct? That's what it appears to refer to in both those documents.
Commissioner Park through the chair. Yes, I believe that's correct. The qualitative risk analysis that is described in the risk section of the MND takes statewide averages into consideration in their analysis. I can double check on that.
Yeah. And I also note that in the references, the bibliography, so to speak, for both those documents, they refer to getting data from the I think it's 2017. Anyway, it's from the ExxonMobil trucking project that we were just referring to. It's EIR. Do you know what it was pulling out of that EIR in the general sense? Was it just the methodology or those statistics? Do you have any idea?
Commissioner Park, through the chair, yeah, I would have to go back and check. I know the QRA was done specifically for this project. However, maybe some of the assumptions or inputs into the modeling were based on some assumptions also made for the Exxon EIR, but I would have to go back and read through and check that.
Okay. Let me move on. Mr. Villalobos, could you pull up the aerial map that I have there? I'm trying to do these in order to make it easier for you. Okay. This is something I prepared from other maps that are out there of Highway 1 and Harris Grade, and of course Google Earth, because that's a Google Earth image, and from information that's in the staff memorandum. I'm trying to put it together in one place, and you can see down at the bottom, it says Burton Mesa 476, and that's a reference to the Burton Mesa project that's in the city of Lompoc. I believe it's been approved already for 476 units. And you can also see little cars that show the where additional roads will enter into Harris Grade and Highway 1 as described verbally in the staff memorandum. And that's 3 on Harris Grade side of the intersection and 1 on Highway 1. Is that correct?
Commissioner Park, through the chair, yes, that's correct. That particular Burton Ranch project will install designated turn lanes onto Harris Grade Road in those locations.
Yeah. And then up above that, you can see another little house, which is for a housing project. It's the Apollo project. It says 302 because that's what was sought in the rezone for the housing element. This one was approved for rezone, correct?
Commissioner Park, through the chair, I'd have to check. Since I'm not the planner on those, I'm not intimately familiar, but I have data when we checked the housing development website as of late last year.
And I presume it must have been because why else would you have included it in your staff memorandum? And I didn't see any reference in the staff memorandum to entrances into that project directly from Highway 1. Do you know if there are any?
Commissioner Park, through the chair, that level of detail wasn't looked into. I just displayed the current applications that are currently in progress in various application phases.
Okay.
So to directly answer your question, no, I'm not sure what, if any, of those road improvements would be for those projects.
Now, you had a very interesting set of statistics in that part of your staff memorandum, and one said that in this immediate area and in Lompoc, there's likely to be a projected 9% increase in traffic by 2031, according to the EIR for, I think it was for the housing element. Right. And also it said 60% up in Santa Maria. Did that 9% include that Burton Mesa project for 476 units? Because I don't recall it being part of the housing element. Maybe it was in the city of Lompoc. But that's my question. Will that 9% figure be even higher because this Burton Mesa 476 units, or is that incorporated into that 9% figure that was in the housing element EIR? Do you know?
Commissioner Park, through the chair, I personally don't know. Aaron may know, but I'm assuming it wouldn't be because the Burton Mesa application was submitted years ago, was approved years ago, and will be built this year, while as the other housing development projects are projected out to 2030. So I would assume that it's not included.
Got it. This may be a question really for Sentinel, this next one, but in case you were involved, I got to ask it. Was there any examination of alternative trucking routes, such as the service road that's shown there, that Sentinel has to this project?
Commissioner Park, through the chair, from my understanding, that was not considered an alternative route. Sentinel could speak more to the condition of those oil field roads, if they would be able to handle a truck capacity and in the limits of what's being proposed under their project. But to my knowledge, that access road through the oil field up to 135 wasn't included in their project description.
And typically you don't consider alternatives when you've got an MND, right? You guys are the experts on this. I'm not.
Yeah,
but
Commissioner Park, through the chair,
if there's an
that's
EIR,
correct.
but if there's an EIR, you do look at alternatives. Okay. Let me go to since we're looking at that road, Mr. Villalobos, can you put up a slide that's the east end of that road, the entrance from Harris Grade? Oh, I'm sorry. You've got this. By the way, this shows the intersection of Harris Grade and Highway 1. Gives you an idea how major it is, and also that the trucks would be making that right-hand turn on that. I don't even know what you call that. Commissioner Bradley, you must know. You've done this for decades.
Oh,
What do
the
you?
free right turn on the lower part of the bottom
No,
part of the X?
that right turn that, which avoids the intersection
Yeah.
and there's a yield.
I
What's
think they call it a free right.
a what?
A free right.
Free right? Okay. And I think it bears some significance that trucks waiting to go through there, given their lack of acceleration compared to cars and their size, may be waiting a while to make that turn and get the yield. But let's move on to the next picture. It was the one for the entrance onto the service road from Harris Grade. There you go. And I believe this to be the just below, just to the south of the oil and gas plant and where the truck racks would be. And it's the start of the road through the Lompoc field. Okay, and the next photo shows the other end. Can you go to that? Very good. Very good. Very good. And you can see that also has the Sentinel logo on the sign and some sort of a pipeline coming out. It's an all-service road, and that's at the other end of the oil service road that comes out on Firefighter Road, which you get to from Highway 1, and from here down Firefighter Road to Highway 1 is about 500 feet. The next slide shows some apparatus at the end of that road. There you go. Shows a very large graded pad. Shows a Sentinel Peak Resources, a logo and sign to the right, so it presumably theirs. Shows plumbing apparatus for oil. And I wonder if anybody on staff knows what this is.
That looks like a well to me.
A well.
It's a water injection well.
Like produced water and then to send it back in?
Correct.
Gotcha. Okay. And did I have others, Mr. Villalobos? I just want to...
Yeah, that was the last photo.
That was the last one. Okay. Let me finish with my questions then. I asked you about the alternatives. Bear with me for a minute. I numbered my questions. let me ask about the adaptive management plan. I want to make sure I understand it. And I do want to say something. I saw in some of the public comment criticism of staff for including this and somehow bringing it up at the end of the first hearing when people had already gone home. That wasn't staff's fault. That was my fault. I suggested this idea and staff pursued it, but I don't think staff should get any heat for done something underhanded. I may have done something that was unwise, but in your opinion, but anyway, it's me. So let me ask about this. Level 1, these are for non-fatal accidents, correct? And so a non-fatal accident results in a report in the quarterly trucking report and nothing else unless there's a number of them. Is that right?
Commissioner Park, through the chair. Yes, that's correct. Under level 1, no injury or an injury accident would just result in reporting to emergency law enforcement, emergency services in the county.
And so since it's any non-fatal accident, it could be a school bus full of 50 kids that gets hit head on by a tanker truck with a drunk driver, and as long as the kids were all crippled for life but not killed, it would be one of these level 1s that would only be reported and nothing else, correct? Under this adaptive management plan?
Commissioner Park, yes, that'd be correct.
Okay, and then moving on to level 2, which does involve 2 or more non-fatal accidents or a fatal accident in a consecutive 12-month period. I note that the second sentence in section 5.3.2 of your memorandum says that there's a comprehensive investigation, and if the comprehensive investigation determines that project trucks were at fault or liable for the accident, then triggers these level 2 responses. I'm trying to understand why there needs to be a showing that the project trucks were at fault or liable for the accident, as opposed to it just occurred.
So, Madam Chair and Commissioner Park, Jackson and I considered this question pretty carefully, and one of the examples of accidents that the appellants brought up was an accident that occurred on Orchid Gary Road, I believe it was, in Clark.
Right, I know about that one.
A single car vehicle where the driver was drinking and driving had smashed into a tanker truck.
Right.
Now, we discussed, would we consider that an accident that would count against someone like Sentinel Peak? And we didn't think that that was appropriate. So this is the way that we drafted it up.
Okay, but if we're just trying to see what road hazards are there out there that the trucks might run into, I hope you see the other side, that one might wonder, why does it matter that they're at fault or not? And I'll get into that later in deliberations. Okay, and then a final question on this is, after some of these level 2 responses are implemented, there's a report to the County Planning Commission within 3 months. I'm trying to figure out what the role of the County Planning Commission is in part of this level 2 response options. It doesn't look like the County Commission weighs in on what responses are to be implemented. I think that's significant because it may not matter what I think, but there being a planning commission hearing means that the public is allowed to come and comment. That's the key thing. That's why I wanted that in Strauss. And so could you elaborate on what the role of the planning commission is if there is a level 2 incident?
Sure. And Jax, please correct me if I misstate anything. So the concept here is that Sentinel Peak is requesting a land use permit for this project, and you're now considering it on appeal. And so if the project is approved and we move forward, you're approving the project today. if they come back for some kind of compliance reporting, the intent is that that reporting be limited to a report, not some potential future action by the commission to change, modify the project, because that's a new project. And Sentinel Peak would not be requesting a new land use permit at that point. They're just coming back for a compliance report. So we structured the adaptive management plan in such a way where the management actions are built into the plan at the compliance level rather than coming back and providing them to the commission at the commission level. Because that's a future action that would require possibly permitting, possibly CEQA. It opens up a whole nother set of actions if we were to do it that way.
Okay. I don't necessarily like that, but I appreciate your explanation. And I have no further questions this time. I certainly will later. And I want to thank you, staff, the audience, and other commissioners for bearing with me as I went through this stuff. But I think that doing it now will help have a more efficient outcome ultimately here today.
Thank you. I do have a couple questions that aren't repetitive. So, let me look at my notes. In the adaptive management plan, does the county have any other projects, and actually in the conditions of approval, that have a 25-year reporting timeframe?
Commissioner
Chair
Bradley,
Bradley.
yes. Oh, Jack's let me handle this one. We do have mining projects, and I'm thinking of Cal Portland and Hanson mining projects that are along the Sisquoc River there that have timeframes built into them. And we've had to come back to the commission with extensions for those projects. Those are the only ones that immediately come to mind.
Interesting. Okay, and in all the discussion of traffic, when I'm looking at the MND, and by the way, thank you, staff, for including the MND in the original staff report in this packet. It's nice to have it all in one place, right? And I see that you actually did revise the MND for this, so I'm actually looking at page 88 of your MND revised, dated April 2024, table 4.14-2. where you've given us some vehicle accidents along Harris Grade and Highway 1, and you added in the link of Highway 1 to 135. This is all really interesting information, but I am certain there is a circulation element policy, as well as it being mirrored in most of the community plan policies, that talks about adding traffic to intersections that have geometric considerations that we want to avoid. And so normally, how I thought it worked is that you looked at what is the anticipated, the state of California, Caltrans has a terminology that says expected accident rate. I mean, they actually give you, every road has accidents on it. That's kind of expected. And so for the geometry, for the location, for the kind of traffic, usually Caltrans comes up with an anticipated expected accident rate. If we had a traffic engineer, they'd probably correct my terminology, but I know that's a really significant thing. And I'm not sure that that was included in the MND. Does that sound familiar, Jackson? Ms. Ibarra?
Yeah, Chair Bridley. So I'm not familiar with Caltrans' expected accident rates. They were not considered and included in the MND. Again, that accident data was included in the final MND as a response to comments. However, the county environmental thresholds really focus on county policies for roadway standards, intersection standards, et cetera. So the MND describes how the project would hold up against those county thresholds.
So in this part of your MND on the environmental thresholds, we have roadway standards, which is volume oriented here. But I thought there was another standard that talked about geometry and those kinds of conditions. No? I mean, did you give us all of the circulation element policies under CEQA?
Chair Bridley, yes, to the best of my ability, I'm sure that I included all of the main elements of the comprehensive plan. I can't think of a policy that requires geometric hazards. Maybe there's a CEQA threshold that a project cannot introduce hazards, like a roadway hazard that would create a geometric hazard. Maybe that's what it's referring to, but I don't believe there's any other county policy that directly addresses that.
Okay. Maybe I can look that up because I know it exists, and it exists for this kind of a discussion where, there might be, the volume itself isn't going to be a problem, but if you have a link or an intersection that already has a higher than normal accident rate, just care has to be taken about adding traffic to those locations. So under questions, I think maybe that's it. Those are my only questions. Is anybody else? Commissioner Martinez?
Yes, good morning. And my question is to focus on the trucking company financial responsibility. Could you give me more clarification of what this is? Is it insurance? Is it just a promise to indemnify, which I've seen they indemnify the county, but...
Yeah, Commissioner Martinez through the chair. So one of the conditions that we added is that the trucking company has to demonstrate financial responsibility if there were an accident. I can pull up the exact financial number that we added. I'm blanking at the moment, but it's a certain financial amount that the trucking company would have to provide in form of a certificate of insurance or something like that, that would demonstrate they have the financial capability to respond to an oil spill if one were to occur.
Okay, well, I'm interested in seeing and hearing what that number is, because that's important to at least me. Thank you.
Yeah, let me look it up.
Okay, Commissioner Park, you're finished, right? Your light's on. Just want to make sure.
sorry.
Okay. All right, so with that, we've completed questions to staff. Does anybody want to take a quick break before we go? Yes, we're going to take a 5-minute break, and then we'll proceed with the appellant. And what I've talked about, both the appellant and the applicant, that they will all get 15 minutes with 5 minutes at the end for rebuttal. So give us 5 minutes to come back, and we will start that. Oh, it's time for we're resuming our hearing of February 12th, and now we are ready for the appellant's presentation. 15 minutes, 5 minutes for rebuttal. If you can do it, unless we will adore you.
Thank you very much. Good morning, Chair Bridley and Commissioners. I'm Ken Huff, Co-Executive Director of SB Can, the appellant in this case. For 23 years, SB Can has been working to support sustainable communities and protect natural resources. Public safety and resources protection necessitates this appeal. The project involves significant risks of accidents on our roads and highways that need to be studied or avoided. We have urged your commission to order preparation of findings for denial, and we now request your consideration of our council's arguments supporting denial. So I'd like to introduce Mark Shaitillo. Thank you.
Thank you, Ken. Good morning, Madam Chair, members of the commission. Mark Shaitillo on behalf of the appellants. We have a few slides here that we put together with the PowerPoint. And roll.
Oh, Mr. Shaitillo, just hang on a second. County Council, you wanted to clarify something about when these materials were submitted.
Madam Chair and Commissioners, there were a number of documents received, one of which came in after the deadline from the applicant's team, just a little bit over 1 page. So if the commission would like it entered into the record, that would be done by a 4/5 vote.
Okay, why don't we decide on that now? Are you understanding that I think Mr. Shaitillo's was submitted on time, but the applicant's was submitted after the 12 o'clock deadline, longer than 1 page. So does the commission want to accept that into the record before we start?
I'd kind of like to know what it is. I guess I didn't see it.
It's a 1.25-page letter from the applicant. If I tell you what it is, then.
Yeah, right.
I believe it was in response to Mr. Shaitillo's letter.
Right. Yeah, it was in response to Mr. Shaitillo's letter, so.
I'm personally just not in favor of it. I would just say they can address it to us during their representation, especially if it's a response to a letter that was submitted in time. That would be just my suggestion.
Okay.
I think that makes sense, what Commissioner Martinez said.
Okay. So with that, just to clarify, we are not accepting the applicant's letter into the record formally, and you're, of course, free to reiterate that in your verbal comments. Sorry for that diversion. Mr. Shaitillo, please go ahead.
All right, thanks for clarifying, and I'll look for their response. I can't respond to it because I haven't seen it, but I'll save that for rebuttal, for the rebuttal part. Well, thank you, Madam Chair. My office was recently involved in this project, and we did submit a letter by your noon deadline identifying a number of issues. I want to focus in my presentation today, however, on the legal issues that empower and restrict your commission's consideration of this issue, both the Land Use Development Code, CEQA, and the findings requirement. And I'm going to summarize our appeal here with this slide. We believe that the project doesn't qualify under the Land Use Development Code. It's inappropriate to use a land use permit, and that this project requires what is identified in the code as an oil drilling and production plan requirement, an oil drilling and production plan. And that requires an entire higher level of review, and it gives additional discretion in the findings that you must make. So that's the fundamental first error that we've identified, and I'll cover it in just a moment. Secondly, that CEQA requires an environmental impact report to consider the project impacts. There is evidence of a potentially significant impact to public health and safety. A fair argument supports that evidence, the finding of that impact, and so you're required under law to prepare an EIR. And the other two issues are findings. You can't make the CEQA findings, and you can't make the general plan and the land use and development plan, or land use and development code conformity findings because of both the land use policies and because of the need for the production plan. So we ask that the staff be directed to prepare findings for denial. So first issue, in the land use development code is really the scope of the project and the scope of the review. This is the first time that trucking off of this site will be considered. This is a new trucking proposal. This is not a restart of a prior trucking proposal. And it's important that you look at the whole of the project, not just on the site where the truck rack is going to be installed, but the entire 165, or it may actually be closer to 190 miles as we measure the road miles associated with the proposed route that the applicant has put forward. And this is critical to your commission's jurisdiction. The Land Use Development Code defines project to include the whole of the activity, recognizing that it may be subject to more than one entitlement for use by one or more public agencies. So you can't truncate the project just to the truck rack. You really do need to look at the entire breadth of the project. And the San Ynez unit was, the Exxon precedent is instructive here because that did look at the whole of the project. This project enables over 60 million miles of oil tanker truck travel through 5 counties. So there's a significant out-of-area impact that needs to be addressed. And so in considering what level of review, whether the land use permit is correct or whether you need to do an oil plan, the oil plan under the code itself requires, it applies to the equipment for the transfer of produced hydrocarbons to tanker trucks. So it's expressed in the code that this is the kind of thing that should be considered under an oil plan. Now, staff has taken the position that it's actually exempt because for reasons that they've kind of summarized in their staff report, we don't believe that it is exempt from the oil plan requirement because the whole project includes a number of disqualifying components. One, it can only be lands with certain zoning. The whole of the project transcends a number of different zoning areas that are not appropriate for the exemption from zoning. It only allows projects that are within a designated state oil field, and the trucking is going to go well beyond that. The trucking is going to be within 100 feet of water courses and on roads that are eligible for designation as scenic highways. So those disqualify it. In addition, the requirement of the oil plan disqualification is only allowed if the project will not disturb map locations of rare and endangered species, delicate habitats, and prime examples of ecological communities, which it does when you look at the whole of the project. And finally, the whole project will result in potentially significant safety impacts. So therefore, you may not approve a land use permit for this project. It is subject to an oil plan requirement under the code. Secondly, and moving to a CEQA issue and a piecemealing issue, this site is used for a number of other oil activities that need to be considered in conjunction with the proposed project. The Lompoc Oil and Gas Plant processes or has processed the Point Pedernales oil off of Platform Irene. Now, and that was transported out through Line 300. Now that operation is shut down. Staff hasn't given us the complete picture of the activities that are going to go on this site. Is the Point Pedernales oil also going to need to be trucked? Is there another trucking project coming down the line? Is it going to involve multiple truck racks, as some of the larger ones have entailed? CEQA requires you look at the cumulative impacts, and I think the project as it's brought forth to you really represents a piecemealed approach to activities on this site. CEQA does not allow that. It requires that you do a comprehensive environmental analysis and consider all of the reasonably foreseeable cumulative projects that may have similar impacts. And clearly there is something else going on with the Lompoc Oil and Gas Plant that needs to be articulated as part of your commission's review. And I would point out that the pipeline restart, which is really, I think, maybe what the applicant thinks will happen in the future. We know that pipelines are commodities. They tend to be shift between companies, as do these oil assets. The pipeline restart will be encouraged by a denial of this trucking permit because these folks want to get this commodity to market. But if you approve the trucking rack, that will retard the incentive to get the pipeline moving again. So it's important that you look at the whole of the project and recognize the consequences with respect to the operator's behavior. The second CEQA issue that I want to underscore is that the project does entail a significant transportation hazard impact. And there are no county thresholds. However, in CEQA Appendix G, they identify 3 relevant significant triggers or thresholds. If a project triggers these kinds of impact, then it is ordinarily considered to be significant, and the mitigation measures and including the adaptive management plan are inadequate and incompetent to mitigate those impacts to insignificant. So the need for an environmental impact report is triggered. The 3 relevant triggers are: does the project create a significant hazard to the public or the environment through the routine transport of hazardous materials? And crude oil is a hazardous material. So that's the first assessment. Does it create a significant risk to the public or environment through reasonably foreseeable upset and accident conditions, including the release into the environment? And, a couple of illustrative photos here of the kinds of impacts and the kinds of significance risks that these sorts of things do involve. And then finally, letter G is whether the project would potentially expose structures or people to significant risks of loss of injury or death involving wildland fires. And there's some discussion in the materials about the vapor plume that is associated with the transportation and trucking of crude oil, and when tanks are ruptured, the potential for significant impact. Now, it's important that the full CEQA analysis be undertaken, in part to give a more robust analysis of these impacts. And we have seen the risk analysis, which frankly is somewhat unbelievable, that 239 years of travel of these, say it's about 1 million miles of travel per year for the project as proposed. It would take about 200 million miles of travel of these trucks to involve a single accident involving a 5-gallon oil spill. Now, we've seen either there's a whole lot more trucking that's going on behind the scenes, and there are hundreds of millions of miles of trucking of oil transport trucking that's happening, and these accidents that we've seen on a pretty regular basis reflect that statistical norm. But I think that that's not the case, that in fact, the analysis, the qualitative risk analysis, which was a comparative risk analysis, not a raw qualitative risk analysis, missed the risks that are associated with this project and these activities, individually as well as cumulatively. So that's what the environmental analysis needs to address, and it needs to include alternatives so that you're informed as decision makers as to the appropriate kinds of options that you have with respect to the project. The transportation route is rife with hotspots and difficult areas. On the lower right-hand side is the, let's see if I can, no. On the lower right-hand picture here, you can see the close-up site. It goes through the Burton Mesa Ecological Preserve on Harris Grade Road. These are not roads that are built for this kind of regular traffic. It goes right through several residential and urban areas as it traverses through Orcutt, Santa Maria, and then on the far left panel, it's a little challenging to see, but the reddish areas are identified as areas with higher rates of truck crashes. Excuse me. So this whole entire route from its very beginning through Santa Maria and Orcutt, through the Vandenberg communities, and then up onto 101, and then Highway 4146, that's colloquially known as the Blood Alley in San Luis Obispo. I think anybody who's has driven that has witnessed it. There's been some improvements to that. The critical intersection of Highways 41 and 46 is under construction now. That was the site of James Dean's death and is a particularly vulnerable area. However, along this route, there are many, many risks. This route crosses dozens of creeks through hundreds or dozens of mapped habitat areas for sensitive species and through chaparral and vulnerable wildland areas. And so it really is important that you recognize this route and its vulnerability. I want to note the failure of the county to adequately scope this environmental document early on in the process. Scoping is a critical step in CEQA compliance, where you identify all trustee and responsible agencies and other parties that may have an interest. You notify them of the project and you solicit their input on the scope of potential impacts that need to be considered in the EIR. This was done in an after-the-fact manner for this particular neg deck, and that's really deprived all of these communities in a full articulation of the significance of the impacts associated with increased truck traffic in these areas. The last point I want to close on is the general plan and land use policy, land use development code consistency determination. While there are not express and overt policies that prohibit trucking, there are policies, land use element policy 10, maximize the use of available or planned multiple use pipeline, maximize that use. Policy 12, transportation of oil received from both on and offshore fields, and it appears that's the case for the Lompoc oil and gas plant, shall be by pipeline with maximum mitigation for any alternative mode. So this is not the complete policy, but it indicates the strong preference under the county's comprehensive plan for oil transportation by pipeline. As I started with, the land use development plan requires, or code requires, an oil plan, not a land use permit. And then, of course, in the climate action plan, we have a couple of relevant policies, with the last one being to limit the increase in fossil fuel extraction emissions and develop a sunset strategy. So in closing, we believe that there are 5 independent reasons for denying this project. The failure to have the proper permit type, the failed scoping and flawed CEQA analysis, the project description omissions, and the CEQA requirement to recognize the significant impacts, and finally the nonconformity with the general plan, land use development code, and the climate action plan. So with that, Madam Chair, I appreciate your attention, and if you have any questions, we'll be here, and we'll reserve the remaining time for rebuttal. Thank you. Thank you.
Okay, now we go to our Sentinel Peak applicant. Just start with disclosing your name for the record, please.
Thank you, Chair Bradley. Good morning, commissioners. My name is Michael Mills. I am an attorney representing the applicant today. I'd like to first begin by appealing to your sense of fairness, decorum, and your rules of procedure. The February 11th letter that was previously discussed and was rejected by the commission was a letter of objection. It was a letter of objection to appellant's February 10th submittal. And just by way of brief background, this appeal was originally filed in April 2024. It was heard in August 2024. Both sides gave full presentations. The matter was debated. The commission had numerous questions. Staff was assigned with specific tasks to work on and come back and report to you on, including traffic information, the adaptive management plan that Commissioner Park had requested, which Sentinel Peak agreed to. And as you just heard in appellant's presentation now, their appeal is entirely different. It is a new appeal, and this proceeding should not start over on February 10th. That was the basis for our objection. As you saw in the last slide that was presented, the 5 reasons they give now for their appeal are entirely different from the actual appeal that is on file before the Planning Commission. So I ask that you reject the appeal, and with that, I want to reserve the rest of our time for Mr. Dave Budde.
Madam Chair, members of the Planning Commission, My name's David Buddy. I'm the Environmental Health and Safety Manager for Sentinel Peak Resources. Do I have a clicker? I do. Okay. Sentinel Peak Resources is committed to compliance and protecting the health and safety of our workers, the community, and the environment. We have our team here today, myself, Ms. Patty Cook, and Paul De Lorenzo. The Lompoc oil field has been producing since 1903. SPR took over operations in 2017, and as you heard, the pipeline has been shut in since January of 2023. The Lompoc oil field operates under several permits and existing regulated, or is also regulated by numerous agencies. We have a strong track record of environmental compliance and has selected a trucking company that matches those obligations. This project is a straightforward approval that the county code assigns to the director. The director has issued the approval in accordance with the law. There is no basis to overturn it. The Planning Commission has reviewed, is only occurring because of the appeal that has been filed. The adaptive management plan further strengthens the county's conditions of approval. It's a voluntary response to public and Planning Commission concerns. The adaptive management plan applies to project trucks which will be equipped with enhanced safety features in accordance with the project's mitigation measures and conditions of approval. Exxon's project would have put 70 trucks per day on the road. Sentinel's proposal is for 6 to 10, and a likely average 5 trucks per day. The environmental impacts and findings are analyzed individually and are project specific. The mitigated negative declaration determined that there are no significant and unavoidable impacts. Staff has talked about the other operators that operate truck racks in the county. Pictured is our Arroyo Grande truck rack, which is operated since 1979, accident-free. We've touched on the accident table in staff's mitigated negative declaration, which attributes the primary cause of traffic accidents to passenger vehicles and not commercial vehicles. The Lompoc truck rack was not previously installed because we had a pipeline outlet, and that was the preferred option. The conditions of approval include the truck hazard mitigation plan, which we've talked about, requiring multiple measures, including geographical management systems, cameras, roll stability control. SPR will also prepare a trucking plan, which will be approved by the county to include notification and protection measures, response resources, training and drills. Additionally, the adaptive management plan adds robustness to the hazard mitigation plan with additional reporting requirements, which we've discussed. Sentinel Peak has a vested right to produce oil due to the historic operations at the Lompoc oil field, including the valuable producing mineral rights and associated mineral leases. The truck rack is only a mechanism to exercise those vested rights until the pipeline is restored. Project emissions do not exceed significant thresholds set by the county. SPR has been a contributor to the county through tax revenue, local job creation, and the support of local businesses, and we look forward to continuing that relationship and in being involved in the county. SPR has worked with staff and the Planning Commission to incorporate the adaptive management plan, and we recommend and urge the Planning Commission to deny this appeal. Thank you.
Are there questions? Yes, Commissioner Reed?
Yes, I have a few questions. First, this truck rack and the trucks, do you have any plans to use them in the future? At such point, any of this Point Pedernales oil becomes available? Any plans to use those trucks in this plan to transport that oil?
The plan before the commission is 6 to 10 trucks per day that average, based on the annual total, approximately less than 6 trucks per day.
Right.
Our actual usage based on our production is less than that, less than 5 trucks per day. So there's no allowance for any other oil
Okay.
production. It's only for our use. That's Sentinel Peak's use.
Okay, now I have a few questions around the adaptive management plan. Although I find myself agreeing with a number of the letters that were received, I have some issues calling something an adaptive management plan because it infers you wait until there's some sort of incident and then you try to change things to accommodate that. I spent 30 years in the healthcare business, and I'm much more an advocate for preventive medicine. So I'd like to suggest some things that could be a part of the hazard mitigation plan. And we've talked about this in prior meetings. First, and probably simplest of the bunch, are restrictions of your trucking at certain critical times along Harris Grade Road. I'd like to suggest, and well, it'll have to have it if I'm going to vote for it, restricting trucking from the hours of 6:30 to 8:30 in the morning and 2:30 to 4:30 in the afternoon to reduce the presence. And I realize there are few trucks, but to reduce the presence of those trucks during the times of day when children are going to school or getting picked up in school, and then the major time when people are leaving work in the morning along Harris Grade Road.
Yep, we have discussed that at the past hearings, and Sentinel Peak is willing to accept those restricted hours.
Okay.
Mentioned that previously, and nothing has changed. We're still willing to accept those.
So you will include that. All right. I have another, the term of this thing, 50 years. I mean, that's been consistently an item that's produced concern and opposition. And, you know, unless I think of things I did 50 years ago, 50 years seems like a very long time. I would be more comfortable. You talk about a 25-year review. I think people would find it more palatable if it was for 25 years with an option to continue for an additional 25 years.
Yeah, that's been written into the adaptive management plan to have a comprehensive review prepared for the Planning Commission. And we can go into further discussions at that time.
Okay, so with respect to the actual trucking company, then that is which company?
Gazelle.
It's Gazelle.
Yes.
All right. Well, what's their record like?
Gazelle
Safety.
has an excellent safety record. They've been recognized, I mentioned, by the CHP, California Trucking Association. They are well regarded for their safety.
Okay, well, myself, personally, I've actually traversed, the route from Santa Maria out along 41, 46 to Fresno, an average of 3 to 5 times a month since 1991. Well, apparently, according to Mr. Chatillo, I'm lucky to be alive. I'm glad to be here. But I have, in those many, many years, found myself interacting or following a great many Gazelle trucks. So I think, attest to the fact their drivers seem to observe the rules. And they are also controlled by GPS and carefully monitored. Now, I know that, excuse me, I'm getting a bad cramp. I have to move a little bit. It's not because of inattention, but okay. at the worst times. But no, but I know you're going to be making regular reports to P&D with respect to accidents, other things. I just have an additional thought. How about if there develops a pattern of drivers getting citations or not observing law? Is there any reporting involved citations received by drivers? Is that part of any of the reports you
I
received?
don't believe that is specifically outlined in the adaptive management plan or the mitigation measures. We have no issue incorporating that into it. The safety measures that Gazelle employs would identify those, and they're easily quantified and identified for reporting. So that's not an issue.
Okay. That's all I have right now. Thank you.
Okay, Commissioner Cooney?
Thank you, Madam Chair. Good morning to you, Mr. Buddy. I'm struck by the important issues here are not within any single frame, but really go out in different directions. And you being an environmental specialist for the oil company, I'd appreciate you sharing your opinion as to the argument by Mr. Shatillo that the County Planning Commission cannot act without preparing an environmental impact report, as opposed to what did happen in terms of environmental review with the mitigated negative declaration.
Yeah, I would say that, do you want to say, okay. Sorry, Kristen wants to make it.
Good morning, Madam Chair and Commissioners. My name is Kristen Castaños. I'm an attorney working with Sentinel Peak Resources, and I was hoping to address some of the CEQA legal arguments that were presented by the appellants today. And from my legal opinion is that staff has done an excellent job preparing the mitigated negative declaration, and that it fully complies with all requirements under CEQA. The requirement to do scoping only occurs if an EIR is required, and where staff has made a determination that there are no significant impacts that cannot be mitigated to less than significant levels, there is no requirement for an EIR. The trigger for an EIR, in this case here, where a mitigated negative declaration has been prepared, is if the appellants can demonstrate substantial evidence of a fair argument that there is an impact that has not been mitigated to less than significance. What's important is that substantial evidence is very clearly defined in the law. It does not include non-expert opinion. Much to my dismay, it does not include attorney opinion. It does not include conjecture and speculation. It includes expert testimony and evidence. And we have not heard any substantial evidence today to suggest that there is a fair argument that any of the impacts of this project have not been mitigated. And in particular, the traffic hazard impacts that the appellants have raised and discussed today are fully evaluated in the mitigated negative declaration. There's a very exhaustive traffic analysis. The risks, all of the factors in the checklist that are required to be evaluated under CEQA have been evaluated in the document, and there is an explanation and mitigation measures included to reduce all of those impacts to less than significant levels. And again, no substantial evidence to support triggering an environmental, a higher level of environmental review. And then also with respect to the whole of the project and the scope of the project, there's a lot of law that also defines what is the whole of the project. The Lompoc Oil and Gas Plant is a separate and distinct operation that will not be impacted by the proposal here. It is a separate and distinct project and is not part of the whole of the project that is before you today. Similarly, the drilling and production operations that are vested and already authorized at the site are not part of the whole of the project. They are already vested rights that Sentinel Peak has the entitlement to continue regardless of this decision here today. So the project is defined correctly in the mitigated negative declaration to include the construction and operation of the truck rack and the movement, the transportation from the facility to its ultimate destination. And I'm happy to answer any other questions about the CEQA analysis.
Well, I'll just follow up with one, and that is, I understand what you've just explained leads you to believe that there is no basis for further environmental review, that it's been done sufficiently to support the path forward that Sentinel's looking for. Correct?
That's correct.
Okay. Well, it sounds to me like now we have both sides of the environmental argument, and my question is really going to be, this is going to court, and the parties have very different views of the requirements of CEQA. So we, as commissioners, have a duty to be careful about which environmental review we adopt. But thank you for your contribution.
Thank you. Don't leave yet. Commissioner Park, because I have questions for you too. So Commissioner Park, go ahead.
Oh, I'm sorry. I had a question of Mr. Buddy. But
Yes,
but
yeah.
if you
All the
ask-
Q&A stays away from your time budget. So please, this is a Q&A between PC and you. So
But I think if you had questions of the lawyer.
I'll follow you. That's fine.
Okay.
I would just like to say to Commissioner Cooney, sorry, Commissioner Park, that I feel there's a mischaracterization of the permitting process, just to answer your question directly. And also to clarify a point, there is no drilling associated with this project. There's no drilling planned for the field. It's just existing operations. And there was a comment made there.
Okay, Commissioner Park?
One of the benefits of me being a retired attorney and being on the Planning Commission is I have these excellent attorneys and excellent staff people to get into the hard stuff. And so I can kind of look at what I see as big picture. And I want to get back to that service road, okay? Because, it's just an ugly mess considering the traffic that these trucks will be going through. And, there's different ways of dealing with that, but it's just an ugly mess. And it seems to me if you can avoid that ugly mess and take that service road to get the trucks out to Highway 1, you're just better off in the long run. And my good friend, ex-Commissioner Larry Farini, of course, hasn't been out there for about 10 years, but he assured me it's a very good road. And of course, you would use trucks to service all those oil pads. Now, if I was in trial, I wouldn't even ask you because I'd cross-examine and I'd leave the issue if the other side didn't come up with an explanation. But I'm not in trial, and I'm not cross-examining you. I like you. I like your company. I hope you can get your oil out in a safe way. But I've got to balance the people that live there and can get hurt with whatever inconvenience comes from using that oil service road. So I've got to ask you, can you explain to me why you're not looking to use that oil service road?
Yeah, that service road wouldn't be a preferable route for us. It would not be a preferable route.
I think I know that already because you didn't propose it. So could you elaborate why it's not preferable? I mean, is it, or maybe you can't, I don't know. I'm giving you a chance.
Yeah, I think the elaboration is it's traversing through the field. And I think the safer route for the trucking is as described in the application.
Okay, I got you. By the way,
Our operations superintendent would like to.
Yes.
Chair, Board. The
Yeah.
Paul DiLorenzo, Superintendent for Sentinel Peak Resources. The internal road wasn't built for transporting of crude oil through it. There's a lot of switchbacks in the road that would make it very difficult to make turns. Also, when you pull out on Harris or Firefighter Road, Highway 135 actually is on a drop, and cars come over that at relatively high speeds, and a truck pulling out there would not be as safe as it would be pulling out, excuse me, on Harris Grade Road. So that's why we picked Harris Grade Road.
Now, when you're talking about Highway 1 there, you're talking about northbound traffic coming up a hill and then going over the hill, and then the Firefighter Road's an immediate right, and there'd be problems with visibility of seeing that.
That is correct. I've pulled out on Firefighter Road many times leaving the lease, and vehicles have been on my tail of my truck rather quickly. So it's a very blind spot, and trying to pull a 18-wheeler out there could be more potential for an accident than anything.
You need some kind of right-hand turn lane to speed up to it if
Yeah,
you could
that
do it.
would be the state that would have to put that in.
Oh, yeah, or they'd make you do it and make you spend a lot of money.
Exactly.
Let me ask while you're up here, and by the way, I had forgotten your name, but I remember meeting with you, and I enjoyed that, so I should have stated that in ex parte disclosures. But you must have distribution network of pipelines connecting the various pumps to some central point.
Yeah, so in the field, everything from the field goes to a tank battery that is actually located just off of Rucker Road. So it's the very east part of the field. Our first plans were to put the LAC unit there.
Yeah.
And then exit back on Harris Grade Road coming out because we were very close to Mission Hills. But we did find out that the Burton Mesa is on both sides of our field, and we cannot build within 1,000 feet of the Burton Mesa. So we had to move the truck rack outside of the Burton Mesa Preserve, which gave us that location above LOGP.
And that would have meant you'd be going down Rucker
onto Harris Grade.
So it'd be another big problem. Yeah, I got you.
So,
okay, well, thank you. That's very useful.
Thank you.
I have a question for either Mr. Buddy or your attorney in front of you. We're hearing that, so the question is, I appreciate the points that you made that you believe this is separate from the rest of the activities on the site, but if this is denied, then what do you do with the site? I mean, if we don't allow you to transport the oil from through this permit, then what do you do there?
Shut in.
We can't produce the oil if we can't get it out. So we need the truck rack to export our oil and sell our oil.
So your site would just idle. There's no other function of it as much as we've, your attorney talked about how this is separate and distinct from everything else that's going on the property. However, if you can't get it off with this truck rack project, then does the rest of the site cease to operate or what?
There would be no oil and production operations that would occur.
Okay.
And maybe I can clarify from a CEQA perspective. The baseline for the CEQA analysis is the point in time when the application was submitted and the mitigated negative declaration was prepared. The application was submitted prior to the pipeline being taken out of production. It's just taken this long to get to the
okay. That was your point, that you've got the baseline for the rest of the property in good standing.
That's
okay.
correct. The
All right.
baseline contemplates the existing operation of the continuing drilling operation.
Okay. All right, I got it. Thank you. Commissioner Cooney, did you have anything else, or no? Commissioner Martinez?
Yeah, my question, I mean, there's a lot of mention in the appellant's papers in regards to the pipeline, and from my reading, the pipeline only went to the Phillips 66. Is that even a viable pipeline to transport, if it even became available?
If the pipeline became available again, then that would be our preferred option, and we would shift back to the pipeline.
Yeah, okay. I mean, which I'll ask the appellant this, but I mean, from SB Can's papers, it seems like they're advocating for a pipeline and they'll never challenge a pipeline, which I doubt. But it sure does look like that. My other question was, just from the description that was provided, there's a tank farm by the Burton Mesa. So I imagine now if you get this, what you're advocating for, would you have to then pipe the oil from the tank farm over to where?
There's existing pipelines through the field that'll be utilized.
Okay.
So really, the pipeline runs to that pad that Commissioner Park showed in the picture. So it's just setting that equipment there on the location.
Okay, that answers my question. Thank you.
Yeah.
Thank you. Okay, with that, we'll conclude the presentations and start opening for public comment. I understand there's still 2 people online? Okay. We're gonna, why don't we start with the people in the room?
And I don't have any additional speakers.
All right, thank you. We're going to begin with Linda Lee, followed by Merrill Brooks. And please state your name for the record when you come up. Don't repeat testimony that we've already discussed or we've heard before. If you can just say you concur, that gives you a little bit more. 3 minutes max. Thank you.
My name is Linda Lee. I'm a Lompoc resident, and my remarks will be purely anecdotal, so I hope you'll consider them anyway. In 1975, my husband and I came to the Lompoc area and started using Harris Grade to go from Lompoc to Santa Maria. We hadn't been doing that for much more than a week when my husband was driving a motorcycle to Santa Maria and was forced off the road by a white pickup truck coming the opposite direction. He was forced off the road and down the embankment, and the white pickup never bothered to see how my husband was. He just kept on going. The person behind my husband stopped his car and helped my husband get back up, and eventually they both pulled the bike back up to the road, and my husband returned to Lompoc. Since that day, in our family, we don't refer to Harris Grade as Harris Grade. We call it Suicide Road. My entire family now, sons, grandsons, myself, and many of my friends, don't use that road except in an emergency. And it was just such an emergency only a few months ago that forced me to take that road to Santa Maria. We had one of the many fatal accidents between Lompoc and Vandenberg Space Force Base that blocked off the entire access to 135 and forced people to go on Suicide Road. As I was driving that road to Santa Maria, I tried to imagine oil tankers or oil trucks coming in the opposite direction, and the thought was absolutely horrifying. It should be scary to anyone who knows that road or travels that road. It's a disaster waiting to happen, in my opinion. In the interest of public safety, I urge you not to approve this Sentinel Peak project. Thank you.
Thank you. To be followed by Merrill Brooks. And following Ms. Brooks, we will have Janet Blevins.
Okay, good morning. My name is Morel Brooks. I'm here today on behalf of Citizens Planning Association. CPA is here today in support of the SB Can appeal of the oil tankering project. We have read the mitigated negative deck, and we find it very incomplete. I want to give you some history why there's no truck rack up at this plant. I live 1 mile from the plant. I know this area. We walk. I'm very, very familiar with it. The plant was originally a separation plant that was needed because of the high percentage of hydrogen sulfide that existed in the oil that was coming from Platform Irene. At those hearings, now this is 40 years ago, 42, 43 years ago, the community that I live in was promised there would never be tankering on that road. We all know how dangerous Harris Grade Road is. We tell our children, do not drive on Harris Grade Road. Okay, so we were also told that the facility would be shut down by 2000 because the product would have probably been depleted. Okay, we had some strong sulfur odors, we had noises, we had pipeline corrosion. Okay, at some point near 2000, instead of shutting the facility down, the county allowed another company to come in, and they repurposed the plant as a processing plant. Okay, the next owner decided they had a sludge byproduct coming from the process. And at those hearings, the neighbors again said, please, no trucking on Harris Grade Road. The county allowed 3 tankers of sludge per week, promising no tankers. That's why there's no truck rack. Okay, let's look at the Burt Mesa Ecological Reserve. That's a 5,000-acre preserve that is there because of mitigation. Unocal had to give something for mitigation for a catastrophic event they had, and that's why the 5,000-acre preserve is there. I don't know what the county policy or the state policy is, but how can you mitigate in a mitigated negative deck on land that is already there as mitigation for a catastrophic event? Okay, let's look at the absence of the traffic study. Okay. Please, I have here, and I can send you I'm going to read from the Lompoc record, January 1st.
And I'm sorry, Ms. Brooks, you have 16 minutes left, so.
How much?
15 seconds.
Oh, okay. It just says surges and crashes, 33 crashes as of December 19th, more than double the 16 reported. None of this is in your traffic study. They've already started doing some traffic mitigation. They're out there yesterday in 2 places, Dead Man's Curve, we call it, and the intersection of Santa Lucia Road.
Okay, thank you.
That's it.
All right,
Please
I think you have a question from
accept
Commissioner
the,
Park. Go ahead, just, hold on,
I
Ms.
do have a
Brooks.
question.
Ms. Brooks? Let's try to keep it going.
I was going to tease you about how did you retain your accent after all these 42 plus years, but you and I can talk about that some other time. I read the same papers that you do, except that you live much closer to this site than I do.
Yeah.
And I know that at around the time of our last scheduled hearing, there were 2 fatal accidents, and one was on Harris Grade. You can actually see the tree that got mangled, and you can see the teddy bears up in the tree, that memorial, and that's the little girls that were there. Mm-hmm. And there was another one around that time. And we all thought that, gosh, what does this show us right before our hearing on this? And then, lo and behold, after we continued it, the day before Christmas, there's reporting of another fatal accident. This was on Highway 1 near Constellation Way. Do you have any further information on what fatalities have occurred there since our first hearing in August? Just that period.
Well, I counted about 6 fatalities. That is since you were talking about this in August. You had the 2 children that were killed on Harris Grade Road. Father, drunk driver. The problem was there's no easement off Harris Grade Road. You're on the road, 2-lane highway. It's not a highway, 2-lane road, and then you go into sand. You go into
no shoulder, yeah.
Yeah, there is, and it says there's signs all the way up on Harris Grade Road, soft shoulders. There's no room for error up there. And he was going so quickly, and he's being chased by a CHP. He was speeding, he was passing cars, and the car split in half. The gentleman driving, the father, he survived. The 2 children, from what next door tells us, that part of the car was hit by an oncoming car, and that's what killed the 2 children. Okay, the young man, the 19-year-old that was driving, was right before Christmas, speeding on Highway 1, which they are out there now resurfacing because of all these different accidents that have happened. Okay, he was speeding and hit another car. There's no median there, it's just kind of a grass strip. But again, they're out there, trying to find some resolution to that. Right before, I believe it was early November, at Santa Lucia Canyon, an 11-year-old girl in the back seat, killed instantly, a T-bone, the grandfather pulled out. They think the other car was speeding. I haven't seen any follow-up. The accident that was closed down Highway 1, that was, I think, 6 injuries, several cars. And again, everybody had to go over Harris Grade Road that was heading toward either the base or Santa Maria.
Okay, thank you. We do have a couple more speakers online. So you're saying 6. I think that answered Commissioner Park's question. Are we okay?
Thanks.
Okay, we have 2 more. We actually have 1 more speaker in the room. That's Janet Blevins. Thank you for waiting.
Thank you so much. I would like to thank Chair Bridley and all of the commissioners for the important work that you do. We live in a gorgeous place in Santa Barbara County, and I know that you all want to keep it that way, as do I. Often we are protected from the direct effects of climate change living here, but I know that you are all very intelligent people, and you all know the effects of climate change, including experts are estimating up to 37% of the cause of the recent LA fires are due to climate change, particularly the 100-mile-per-hour winds that precluded any kind of air support fighting the fires. I also need to say that Mr. Reed and I are familiar with one another after serving on the Air Pollution Control District Community Advisory Council for several years together, and our votes were usually opposite one another. I was shocked at the issuing of a mitigated negative declaration for this project. I think it's totally inappropriate, and because there are lots of safety concerns, in addition to the climate concerns of continuing to use more and more oil. Harris Grade Road is extremely dangerous. Now, the plant is at the south end of Harris Grade, not on the real curvy part that's so dangerous, but it would be dangerous considering all of the drivers that come from Santa Maria and use that road, meeting oil trucks coming out of the plant onto Harris Grade at the south end. I can foresee terrible accidents because we have young 16 to 18-year-old, well, a man's brain, is not fully developed until age 25. So we have got all these young kids driving carelessly over that road and coming up to the plant with tankers pulling out would just be a disaster. It scares the heck out of me. I use that road all the time because I drive a small little Prius and I can get to Santa Maria a lot faster. But if trucks are added to that, it would be a disaster. Also, I have a report from a former manager on that property that the office building on that property is sinking.
Thank you. Ms. Blevins, you're just about up, so thank you for those comments. Okay, and we have 2 people online. I'd like to get through those before noon.
Yes, our first speaker will be Lucy Thomas, Tom's Harrington, to be followed by Gianna Patchen.
Thank you. Good morning, Madam Chair and Commissioners, and thank you for your service to the residents in our county. I'm Lucy Tomes Harrington, and my family and I have lived in Lompoc for over 40 years and reside in Mesa Oaks, which abuts to Harris Grade. Before retiring to consult, I was a product line manager and member of the senior leadership team of Raytheon Vision Systems. I urge you today to deny the Sentinel Peak project. Up to 10 tanker trucks transporting crude oil for 50 years along a dangerous proposed route poses an unacceptable risk to communities and the environment along the route. First, let's talk about the dangerous risks to the communities. The route through Lompoc impacts over 2,200 students, parents, teachers, and staff of 6 schools, which depend on this exact route to transport students ranging from TK to high school ages, according to Lompoc Unified School District. In addition, there's over 10,000 students, teachers, and staff who attend Allen Hancock at both the Lompoc and Santa Maria campuses that would be impacted by the route. We've already heard about the statistics of the increase in crashes that have occurred on the Highway 1 portion of the proposed routes over the last 24 or 12 months. Crashes have increased over 50%, cite the source of Santa Maria Sun on January 2025, which quotes Caltrans. Residents along the Lompoc route, like me, living in Mesa Oaks and the Bluff, have a single point ingress and egress from Onstadt Road on the Harris Grade, which literally traps residences in the cases of fires like Rucker Road. Imagine if there would have been a full tanker truck on that portion of Harris Grade at that time. The results would be catastrophic. It intersects the Burton Mesa Ecological Reserve along both Harris Grade and along Highway 1. According to the Fish and Wildlife Department, this is one of the last significant stands of maritime chaparral in the states. A spill of crude oil would be catastrophic. The staff reports impacted parties were notified in February of 2024. Was Lompoc Unified School District and other impacted school districts notified, as well as the parents? Was Allen Hancock? Was California Fish and Game notified? Because I can assure you that the residents, like me in Mesa Oaks, were not. The bottom line is this. This project presents a huge public safety hazard, and I urge you to take the responsible action and to deny the Elkasee project.
Thank you. Our next person online.
Our next speaker will be Gianna Patchen.
Hello, thank you, Commissioners, for your time this morning. My name is Gianna Patchen. I am the chapter coordinator for the Sierra Club Santa Lucia chapter, representing over 3,000 Sierra Club members and supporters in San Luis Obispo County. I'm here today because the Sentinel Peak Truck Rack projects trucks will spend the majority of their miles driven on San Luis Obispo County roads. As you've heard, the proposed trucking route would send 6 to 10 trucks per day round trip for up to 50 years, and of the 165-mile one-way route, approximately 90 miles run through San Luis Obispo County. I am here to share again that the San Luis Obispo County section of the route across the 101, 46, and 41 passes the Salinas River, multiple creeks, open spaces, and agricultural areas. This includes a stretch of Highway 46 where homes, businesses, vineyards, and even a water park are right next to the highway, often with only grass between the roads and structures. Oil truck accidents are not uncommon, with hundreds of oil trucking incidents happening in California every year. This project will inherently increase the risk to our communities, particularly considering that there are pre-existing oil trucks that would share the road with these potential new oil trucks, contributing significantly to compounding risk. We disagree with the staff report's recommendations for this project. We are asking that the Commission deny the Sentinel Peak Truck Rack project, or at minimum not certify the mitigated negative declaration as written. The mitigated negative declaration as written does not fully consider existing evidence of significant and unavoidable impacts from this project, especially those in San Luis Obispo County lines. The spill and traffic risks pose hazards to public health and safety, as well as ecological, water, and cultural resources. Additionally, we continue to highlight that the August staff report states that no environmental justice communities occur along the route, but failed to include any list of impacted environmental justice communities outside of Santa Barbara County, nor consider that communities and neighborhoods along freeways, highways, and in unincorporated parts of our counties are often environmental justice communities. Even if you are not required to consider them, these frontline communities will be the first impacted by the increased spills and traffic risks. For all these reasons, the Santa Lucia chapter of the Sierra Club asks you to deny the project or not certify the mitigated negative declaration as written. We would like to see an EIR that encompasses the entire scope of impact, including in San Luis Obispo County. Thank you, commissioners, for your consideration and work on this matter.
Thank you, Ms. Patchen. That concludes our public comment that I believe we have. So at this point, we bring it back to the commission and we ask if staff has anything they want to respond to during public comment before we go to rebuttal.
Nothing that really warrants immediate response, but we're happy to answer any questions that you guys have.
Okay, well, maybe we can go back to rebuttal by both parties. If we have the appellant.
Thank you, Madam Chair, members of the commission, Mark Chatillo. On behalf of the appellant, SB Can, I'll just take in order some of the points that the applicant made here. Attorney Mills urged that you would reject our appeal entirely and the materials submitted. We went back to the appeal form and we identified the lack of evidence and the abuse of discretion as being the foundation of this appeal, and the materials that were submitted previously to the commission earlier this week in a timely manner amplified those, but didn't change any of the fundamental legal precepts. And of course, it's in accordance with the Planning Commission's procedures and practices. You are sitting as the decision maker now. This is a de novo review, so you have all the authority to consider all the evidence and information that's before you. There was reference to vested rights, but no real evidence was submitted to that. Now, when you're dealing with vested rights, it's important to delineate carefully, based on evidence, what is the scope of those vested rights. And what they said is that they can continue to drill. But the fact of the matter is that when you have a claim of vested rights, you may not expand that right. You may not amplify. And it's our view of this that the truck rack and all of the impacts associated with it are well beyond any vested rights. And these are material and significant changes with a new set of risks that are completely within your jurisdiction to consider. There was some discussion of the risk profile and noting that Sentinel may not have been, or oil trucks may not have been responsible for some of the injuries and accidents. But you need to delineate between the accident responsibility, which may be a third party, and the accident consequences. And here, when you have a fully loaded oil truck or an empty one that has residual amounts in it, the consequences of an accident are substantially different. And that's what your commission has to consider as it evaluates, are there significant impacts? It's not a matter of, well, who was responsible for, one of the accidents, a fatal accident to the driver of the tanker truck was a deer that ran out of the road, and that caused the truck to crash and spill, and the fatality to the driver. The consequences, because it's this kind of equipment, this kind of a truck, and this kind of a payload, amplify the significance. And I think that your commission does have an obligation to consider that and recognize the increased risks that would not be present if the project were not approved, because those trucks would not be on the road. Turning to the adaptive management plan, I think we have concerns that the elements themselves are inadequate. It both entails weak triggers, in part, for example, a requirement that there be an assessment of who's responsibility for a crash before it would count towards the crashes, and then ineffectual actions such as going with a different trucking company. We wholeheartedly support Commissioner Reed's approach to being proactive and preventative. Turning to CEQA, the triggers that are involved here for an environmental impact report are supported by substantial evidence. First of all, I'd like to respond to the attorney. The argument from the applicant was that scoping is only required if there's an EIR, that is, that formal notification process of all the other jurisdictions. Well, that in and of itself is a justification. It's an explanation. It establishes the need, because you have a 165-mile route here with a number of different agencies and jurisdictions, and they should be involved. But she actually overlooked the fact that under 15072 of the guidelines, there is the requirement of the pre-circulation of a notice of intent to circulate a negative declaration to the public, responsible agencies, trustees agencies, and the county clerk of each county in which the proposed project is located sufficiently prior to adoption of the neg deck. So even in the neg deck circumstance, you're not supposed to wait till the last minute and do it after the fact. It's something that needs to be addressed in advance. And in terms of the evidence, I think you heard ample expert evidence from other drivers, from people who have read the newspapers, that have had experience on the road. We are actually all experts when it comes to driving, because we all do it, and we all know what it's like to have to navigate a slow-moving truck in a hazardous situation like that. So with that, I will wrap up and ask your commission to deny this project, ask staff to direct the preparation of findings of denial, and ensure that this project will not go forward. Thank you.
Thank you, Mr. Chanel. So we go back to our applicants team. I'm not sure if Mr. Mills or who. Again, you have 5 minutes reserved.
I'm not going to take 5 minutes. Madam Chair, members of the commission, I stand by my comments, and I think that if the CEQA document was inadequate, your county council would have advised you of that by now. I just a couple of things. Well, one point in particular, any project applicant cannot mitigate the for other people engaging in illegal activity. And many of the examples of the accidents that you've heard today were other drivers engaging in illegal activity. And that is not an impact of this project, and that is not an impact that Sentinel Peak or any other project applicant has a duty or obligation or legal ability to mitigate for. So again, I think we would just submit that the mitigated negative declaration is adequate. I will defer to staff on the noticing requirements. I do believe that all of the appropriate notices were submitted, and in fact, this body is now going to be undertaking a decision on whether or not to approve the mitigated negative declaration, and as your staff indicated earlier, notices were sent to some jurisdictions a second time after the August hearing. It has been 6 months since the August hearing, so I do believe that all of the affected agencies have received notice. And all of the CEQA procedural standards have been met. So we would urge the commission to deny the appeal and approve the project as proposed by staff. Thank you.
Thank you. I think you have a question, Commissioner Park.
Yeah, this is just a little thing. Do you think that the objection that Mr. Mills registered here at the podium was adequate to state your objection, or is there some necessity that the 1 1/4 page letter be in fact accepted?
I think that our objection to the new presentation of the appeal today has been adequately lodged by Mr. Mills. Yes.
Okay, and I had some concern that it took some time for Mr. Mills to state that, and then it might be taken from the time you had. But you've used your time. You have a surplus of time, so I don't think that's a problem. So we'll just leave that as it was. Thank you.
Thank you. Okay, so that brings us back to the commission, and we're poised for deliberations. I have to ask what people want to do here. It's noon straight up. What is everyone's preference? Do you want to take a lunch break, or do you want to try to forge ahead with deliberations? Commissioner Park?
I can go either way, but either way, I need a little break.
I'm looking for some help. So a little break, like a 15-minute would get you through, or are you thinking of a meal break?
You said meal, not
Meal
mail, right?
break,
Okay.
yeah, is the second option.
Just, the standard break we take after an hour and a half of
Okay,
so forth, after we're drinking coffee and
all right.
water.
So any other opinions over there?
I can go either way.
Okay, all right.
You're the one who has a problem because I'm leaving.
I know, my carpool is leaving without me, so I would be inclined to take a 15-minute break and actually come back, because I have a feeling we've had a lot of robust discussion and Q&A. So if everyone can hang on, then I think we could probably wrap it up before we take a full lunch break. Are you okay with that? All right, so let's do 10 minutes body break, as the Coastal Commission calls it, and we'll be back here and then. Welcome back to the Planning Commission meeting of February 12th, 2025. We had our public comment, and now we're back to deliberations by the commission. So is this a joint third and fourth district? I'm just going to look over to that end of the dais and see who wants to start talking.
Here's how it works. The actual truck rack and that stuff is in the third district.
Okay.
Okay. Most of the route that we're concerned about, hazards and all that, down Harris Grade and turn right on Highway 1, is in the fourth district until it gets into the fifth district, where you get into Santa Maria and the turn onto Betaravia Road and all that.
Well, you're on. So do you want to begin our deliberations, Commissioner Park?
I will, and I think there's another reason I should, frankly, aside from just what district, because obviously every commissioner has the right to change their mind, but each of the rest of you expressed sort of a tentative decision on this when we heard it in August. I'm not saying you have to stick with that. I'm just saying you kind of did. And I really didn't. I didn't really know where to go. And, people will think that people that change minds got a problem. I think it's actually an indicator of having an open mind. And I'm mindful of one of my favorite quotes, because it kind of describes me, that a little inconsistency is the hobgoblin of small minds. But I had probably a general preference to approve this matter in August. I've spent a lot of time on the ground there looking at things, which always helps me, always did in my litigation career. And I spent all day Monday, pouring through the documents, and even last night. And I won't be coy. I've changed my mind, and I will be making a motion to grant the appeal and deny the project. But I think it's important that I say why that is, because it's important for the record. Mr. Villalobos, could you pull back up that excerpt I had from the Judge McKee's decision in Exxon? I don't mean to relitigate or re-argue the Exxon case. That would be stupid and wasteful. But I think there's some analogous thinking that we should pay attention to. One, on this issue of, do we have a policy against trucking in this county? You've heard from our county council. You've heard from our staff. You've looked at documents. I'll remind you, there is that one-page letter from Get Oil Out that quotes the board letter that our Board of Supervisors signed off on when it denied the Exxon trucking project. I felt it was an easy question to address back in August because, I looked, do we have something that says policy, a label on it? And there isn't one on trucking. On the other hand, who sets the policies? The board does. And if the board signs a board letter that says that, yes, we don't allow trucking by oil in this county that isn't specific to that project, well, that kind of looks and smells like a policy. I'm not here on the Planning Commission to interpret what the board thinks. And so that's when I want to punt off to the board. If they think there's a policy, then they can decide that, because I know this thing will get appealed there anyway. So that's where I am on the policy. Now let me address other things. Reason I wanted this back up on the screen is to point out how that matter actually was decided by the Planning Commission. And you say, well, what's this got to do with it? If you read the full 30 pages or so of this order, you will see that it quotes Commissioner Bridley and Commissioner Cooney and Commissioner Park at length. Okay, and the reason it does that is Judge McKee looked through what was the substantial evidence behind that decision. Okay, and one thing was common to all of the testimony that was quoted by the three of us. Okay, and that was that we essentially rejected the EIR's finding that there was no significant safety hazard. And that finding was based on, guess what? CHP averaging of accident data throughout the state of California. And the position was taken in that document and by others that Highway 166 was not a dangerous highway. And what's throughout that decision that's quoted is each of us saying, no, it is. And I even got down to the point of talking about driving my horse trailer over the 7 bridges and all this kind of stuff. I think that is analogous to this case. There's some things we don't have. We don't have an analysis of traffic hazards in this actual place. And by this actual place, I'm focusing on Harris Grade coming down to Highway 1 and Highway 1 going on up past Vandenberg. All we have are those a reappearance of those CHP averages for 2-lane roads and freeways throughout the state of California. I think that the people that live in that neighborhood, and it's a very large number of them, and it's growing with all the projects they're going through, they deserve better than that to protect them. And so I think we do need to have that kind of analysis. I also can state a thing we don't have is really much of an explanation of why there isn't direct access over the oil service road through that oil field instead of the proposed plan. Yes, I kind of agree that there's some issues of making the right turn out of Firefighter Road, and maybe having a right turn entry lane would help with that. But there's tremendous safety problems on the proposed route. One could say, well, gosh, Commissioner Park, you just don't understand that we don't look at alternatives in a case like this where there's an MND. That's right. We really don't. But we need to think about it when we weigh, are there hazards? And here we have a specific ordinance that says you are not allowed to take trucks of this size down past Burton Mesa Road to Highway 1. You're not allowed to do that, with the exception if you have no other direct access. And who's to make the finding on that? We are. And I cannot make the finding that they don't have direct access. I think they do have direct access. It's not, as Mr. Buddy stated, the preferable route for them, but they do have it. So I think that aside from the environmental hazards, we have a situation where we can't make the finding that that this project complies with all laws and regulations of the county. That's one of the administrative findings. I do have a concern over safety. It's always been kind of a scary, funny place, but my gosh, with all the fatalities that have occurred just since we first heard it, we've got to analyze that. I thought that maybe the adaptive management plan might deal with it, might mitigate those concerns. I don't think it does. I have been a person that's asked for those on 3 different cases in the last few months. I'm not really pleased with how any of them came out. And it's not up to me to rewrite them. Probably the next time I ask for one, I should be more specific in what I think should be in it, and I understand that. But this one, it does not adequately address those issues that I think we need an EIR for. The idea that it's not triggered until there's a fatality. It's just a fatal error in the plan. Things can happen that are very bad, and in multitudes that require a look-see before there's a fatality or multiple non-fatal accidents. I also criticize the adaptive management plan because it focuses only on remediation of problems where there's liability of the company, the trucking company, or it's their fault. I look back at Exxon, and what I focused on there or brought to everyone's attention was all the unsafe conditions of that highway and also the consequences of having oil spills on that waterway that's crossed by 7 or 8 bridges. And I remember asking residents there about this, and they all said, they thought the oil tanker drivers were pretty good, but they thought the gravel truck drivers were horrible, and that people just driving around on 166 getting frustrated that would pass and you'd have these accidents. I don't think it's relevant whether the Gazelle or whatever contractor that Sentinel uses causes the accident. The question is, are they in a milieu? Are they in circumstances where there are accidents? Here, there have been, there are. It's a dangerous place, and it's going to get worse because we're going to add close to 800 units just between the Apollo and Burton Mesa projects right down there at the Y where this intersection is. And there's going to be 4 road penetrations right there at near that intersection, which people will have to deal with. It will only get worse. We have Hancock has a relatively new facility off of Highway 1. It will expand. Things will happen. So I don't think the adaptive management plan is going to work, and it's too far from working for me to try to tweak it and save it. So in summary, I think this is crying for an EIR. The public deserves it, and we can talk about what's legally required to trigger one. I get it, but I think we have to also look at the bigger issue of what's the right thing to do, and the right thing to do is to have that analysis. I cannot make the 2 of the findings. The first finding is the one that where we are basically saying there's no showing of significant environmental impact. I cannot make that finding. And then there's when we get into the administrative findings, there's the finding that I believe the project complies with our ordinances, regulations, and law. I can't do that because of the law prohibiting trucks going down Harris Grade Road unless there's no other direct access. So that's my reasoning in a nutshell. I know we could go on for hours arguing each point, but that's my summary, and I will be making that motion. Thank you.
Thank you, Commissioner Park. Who wants to go next? Commissioner Martinez.
Okay. Well, my analysis of the situation is one in which I actually would deny the appeal. And the denial of the appeal is just looking at the appeal that was given here today where they're using potential. That word underscores the fact, instead of saying substantial, it's a reach. There's no things that are coming towards me that's saying, hey, this is exactly what's going to happen. Because this kind of transportation is occurring today. It is occurring on the same highways. It's occurring on the 166. It is ongoing. We are not I wasn't here during Exxon. I read all the newspapers about it and all the arguments in regards to the thing. And I'm really going to hold SB Can to its representations in this. If there's ever a pipeline coming through, I'm going to point to this and say, you agree with pipelines. Because in the past, I've heard everybody say no to pipelines because it's not environmentally conducive to the situation. And this is the first time I've ever heard that them saying, well, pipelines is the answer. But the only reason I really pull up the pipeline situation in this matter is because it underscores the fact that transportation of oil has occurred from the site. This is an alternative means of which to transport the oil because the pipeline is not available. In my analysis of the situation, whether we can bring outside thoughts and processes, I can't help escape the situation that this is really an effort to shut in this site. And then they're going to come back around the corner and say, oh, we got idle wells. You need to shut it down. You need to shut down the whole thing. And I think that's kind of what's really behind this, because if the pipeline really came available, I think we're going to hear the other side of the coin saying, well, we don't like that either. I think in regards to the directness of this transportation, I like the direction. I like the way the truck route is. It doesn't go into the bends and the winds, of which the superintendent, the local superintendent, even pointed out and said, look, this is why we don't kind of go that direction, to avoid the exact situations that we were talking about, which is the accidents that can occur. And the accidents that were talked about today, I'm very well aware of them. I'm very well that there was drinking involved, and there's just tragedies involved in those things. And on this route, there was an effort that was made from the last time that this was brought before us by our staff to actually contact those people and reassert the contact to see if anything was going to be mentioned. And it was pointed out on this route that they have significant environmental situations for that create significant risk. I have problems with that because even on this route now you have new lithium battery stations, which cause even more risk. Looking at Moss Landing, that's right there in Nipomo. That's right there by the river. That's right there by an urban center. This transportation, if we're going to talk about the most saturated urban center that it's going to go through, it's my district. And what goes through Betaravia, this happens. It's going through there. It's going onto a major highway. I don't see any concerns, because there is a concern with anybody who's driving the road. It's just the reality of life. And we have to provide, we don't have to, but the reality is that the working interest in regards to this thing is that there's risk in everything, and how can you address the risk? And that's why I asked the question about, the ability, the financial ability, what kind of insurance is out there. Thankfully, I spoke to Commissioner Reed, and Commissioner Reed pointed me to the exact portion where to look to, and I got the answer there. I understand by the analysis of no other direct route, but I'm looking at this and saying, well, we're talking about safety on one end, and we're talking about the direction on the other end. If you go the other way, we're going into where all these accidents are occurring. Why would we go that direction when we have a straight line? Now we're talking about the developments that are going to be going around this route. I moved here from Orange County. When I moved up here from Orange County, I knew where I was moving into. I knew what I was getting into. And for me to turn around and say, well, we're going to develop this and now everybody has to bend to us, that is, that's a dangerous end in regards to what it can do to what people are moving into. It's a rabbit hole for me in regards to things. So the way I'm looking at this is to say, okay, we have this existing facility. It has transported oil before. The pipeline's down. They're not doing it in a tremendous fashion where we're having 20, 30 trucks going out there. It's transporting the oil that's being produced in regards to those things. If they don't do it, you're going to have a shut-in field. Allow them to do this, what is commercially reasonable here. I don't believe there's an environmental impact report that's going to address the situation where every single endangered species or so forth that they're going to go through, because it's happening now, is my point. And I'll make this analogy, and I was just thinking about it when I was driving over here today. We're talking about safety concerns and these accidents, and I knew this was going to happen today. But when we were talking about the wind farms, we knew species were going to die. We're counting how many are going to die and whether it's acceptable or not. That's a concern, and we're talking about endangered species. So I don't understand the difference, and I'm not going to try and meld the difference, in my opinion. I just think of it as something that this is reasonable. This does have a risk. I don't think it's a significant risk because it doesn't add to the existing risk that's already occurring. And that's my position in regards to this matter. Thank you.
Thank you. Commissioner Reed?
Well, to begin with, I respect what SB Can does on behalf of the community and their concerns. And I have known Mr. Huff for 10, 12 years, something like that. And like Ms. Blevins mentioned, we've been most often on opposite sides of the issue. I have actually been on the same side of the issue a few times with Mr. Huff. Today is just not one of those occasions. I think I'm one of the people that Commissioner Park mentioned when it appeared their position on this would have been revealed in our earlier meeting. I also recall at the time of that meeting and the genesis of the adaptive management plan, I believe it was primarily Commissioner Park's suggestion. So here we are today. We have the adaptive management plan, not perfect. I think applicant has agreed for certain modifications, like ban on trucking between high traffic time 6:30 and 8:30 in the morning, 2:30 and 4:30 in the afternoon, agreeing to a shorter term from the 50 years with a potential of a 25-year renewal after a review. Includes robust reporting of any events that are going to be occurring. Furthermore, one thing that was lacking at the earlier hearing, since then, all the respective governments along the route, other counties have been notified. We've received no objections from them on this route. We have noted at this meeting there have been reports of other accidents on Harris Grade Road. And historically, Harris Grade Road has been regarded, because I remember back in the days before there was 135, and the typical route to Lompoc was Lompoc-Casamalia Road, and then over Harris Grade, and I admit it was very hazardous and very scary. And I almost wonder if some of the prohibition on traffic over Harris Grade, as Commissioner Park mentioned, from Burton Mesa on down, was based on earlier concerns of traffic going over the top of Harris Grade, which to me is certainly no place you'd ever want a tanker truck to be. So that's my opinion on that. But my feeling remains that I think the director acted properly in approving this according to our county ordinance and regulations in the first place. Therefore, the appeal was filed. I believe that staff very effectively addressed all of the issues included in the appeal and came to the proper conclusion that the appeal fell short and as such should be denied. I'm in agreement with that. I respect the contributions, the submittal from Mr. Shatillo, but further, I accept the position and findings of the council from Sentinel Peak with respect to those. Therefore, my position is that I would only support a motion that would deny the appeal and approve the project.
Okay. Commissioner Cooney?
Boy, this has been a very interesting, if elongated, matter before us from last summer, and the documents that were produced for this hearing are really excellent. I feel privileged, and we all do, that we get such high-quality legal arguments here at the Planning Commission, and listening to those, as I indicated, I was interested in whether we should have had an environmental impact report, because that was in dispute. In fact, environmental counsel for the applicant indicated, I think her words were, I think the staff did exactly what they should have done with regard to the environmental review. And I think that I was trying to answer whether to approve or deny the appeal based on environmental review, but have concluded that the environmental review was not the deciding factor here. But what we do have is a discretionary review, and we're asked by the appellants to prepare findings for denial and of the project altogether. Certainly, the indication was that the appellants disagreed with the environmental analysis. I'm not so sure, but it doesn't matter to me. I can't approve this. I couldn't approve it last summer. And there's been a lot of learning and excellent counsel. And I might say excellent staff. We had two of the best in Santa Barbara County, and Ms. Ibarra and Mr. Briggs. So I'm prepared to move forward with findings for denial, which will be prepared by staff, and then the possibility of appeal is right before us, and I think we've done everything we can do. I hope that the board and perhaps the courts will be able to make a decision going forward. As a final thing, I want to extend thanks to Morel Brooks, who has been steadfast throughout this entire matter, and who was a terrific member of the Planning Commission for years before she decided to take on more difficult work and appear before the commission. In any event, we had a lot of good input. It's a very close call. We could be wrong today, but I support the motion indicated he would make by Commissioner Park, and I'd vote to side with him.
Okay, very good. Guess that leaves it to me. Interesting. Right in the middle. How about that? And honestly, during this continuation and everything, I could have gone either side easily for a couple of reasons. I'm an environmentalist, but I'm kind of pro-development, and it's odd because I surprise people that way, because I think that when people have an entitlement like Sentinel Peak does, they should be able to use it. However, it's been doing that at this size for a long time, and what has influenced me today, and since this was heard over the summer, was the changing conditions on this roadway. I appreciate how staff amended the MND, and I would be okay with an MND. I don't think it has to have an EIR, because this really comes down to whether we find it's consistent with these CEQA thresholds or not. I also particularly appreciated Mr. Shatillo's citation of Appendix G and those thresholds that talk about, the geometry of a road where you're going to put a project. We should pay attention to that. Are there excessive truck accidents since 2018 that staff has included in our MND? I don't know if they're excessive or not because we didn't have any testimony from a registered traffic engineer or Caltrans. But when I look at the number that got added from Highway 1 to 135 of 19, 15, 16, 18, 41, that looks high to me. And as much as we don't have the expert telling us that's above the state average for this kind of a highway, what's also meaningful to me is everybody that came out and talked to us about this case and their fear of the roadway and the excessive deaths and the accidents. And as much as it wasn't all caused by semi-tractor trailer rigs or anything associated with an oil industry, it's still a dangerous section of road. It is. And that's where I'm having a problem making the CEQA finding, saying this is just fine to add on to that road system, because I think the existing conditions are not optimal. And there's no plan to do anything about it. In our housing element, in improving, all those units, and not including the Burton Mesa, which is by the city of Lompoc, our housing element did not do a great job of looking at infrastructural needs to support all those housing units. I mean, we did actually a very poor job. We had to, we didn't have time. So in this situation, when I look at the number of units that are being proposed in the immediate area, that's another concern I have. And as much as that's, forward thinking in terms of what the future condition is, it's bad now. We've heard that from lots of people. We've seen it in the press. So if it's bad now, and I don't think it's going to get better because we don't have a capital project list that's going to improve anything on this. I don't have a traffic engineer telling me I'm overreacting and this is all fine and within the state averages. I really cannot make the CEQA findings. And so that's my inclination. So with that, what else was I going to say about it? I don't actually have a problem with it being a land use permit. I think I was a little bit hopeful on the part of the applicant and staff because the development plan touching this component, I could have seen it go that way, but like I said, I was on the fence both ways. So my final decision is to go not in support of the appeal, not with the case, primarily on the CEQA findings for assistance in revised findings. So I think we need a roll call.
No, I think we need a motion, Madam Chair. And before we do a motion, I think we also need a date to come back for findings for denial. So if I'm looking at Mr. Briggs real quick to anticipate a date. So if you can give us 2 minutes so we can come up with a date for that motion.
We made it before 1 o'clock. This is good.
Madam Chair and Commissioners, we're looking at March 12th, and that's a Santa Maria hearing. But that is the same hearing that we did continue the emergency ordinance discussion. But this is coming back just for findings for denial, and it is a Santa Maria hearing. So it'd be aligning with having it located in the North County.
Okay. So if we have the motion maker wanting to include that, take it away.
Yeah, I'm going to take a very brief time to add something that I had on the top of my notes and forgot it. I was somewhat surprised to see that the project description for this is still 50 years permit. I thought we discussed that at great length in August. And I the more I looked at this, I thought if everything came into play with all the studies and everything else where I might want to approve this project, I couldn't do it for more than 5 years because we just don't know what's going to happen out there with all the things that are going on. So it's just another reason. I don't know if that matters to anybody, but I wanted it to be on the record. In any event, I will make a motion that we continue this Sentinel matter to March 12 of this year and direct staff to prepare findings for granting the appeal and denying the project.
I'll second that. Oh, I'm going to jump in there. Okay, we have a motion and a second.
Commissioner Cooney,
Aye.
Commissioner Park,
Aye.
Commissioner Reed,
No.
Commissioner Martinez,
No.
Chair Bradley.
Yes.
Motion passes 3-2.
All right. With that, we adjourn our meeting to March 19th, our special hearing in Santa Barbara. February 19th. Wow. Just lost a whole 30 days. Sorry. February 19th. Thank you.